What is this?
Last time was taken for submission of affidavits.
I do not know what is the meaning of this prayer. To direct the opposite parties, more particularly opposite party number 1, Collector Rayagada, to make a through inquiry over the works, that is serial number 127. Then there is a commission against work for which the real truth will be found out against the said work. What is the prayer?
Depends on has already given 2 times to the
Can a court be used as a tool to gather an evidence for you? Can a court be used to gather an evidence for you? You are trying that the court should find out the evidence for you. What kind of a prayer is this?
The petitioner is social workers of the Rayagada area, carried by the village of 5 years, filed this litigation of corruption of.
What kind of a petition is this, sir? I have never come across with this petition, paragraph 5, that in this connection, the villagers of that area are facing severe difficulties when they meet the opposite party number 3 and 4 and told about the matter. They told, who are you? Is this way to draft a petition?
I have already.
The pleadings has a very important role in adversarial adjudication, sir. What kind of a petition is this? What is the main grievance? I could not. I spent some time to understand. I could not figure out what you really want and what is the problem. In a petition, it is so cryptic, not cryptic, may I use the word, so ambiguous. I could not find out that you really want, what is the cause of action, what is the problem, what for you have come to the court. I could not figure out from the petition. If you say I can read from paragraph 1 onwards, tell me if you can understand what you really wanted.
Money already has been sanctioned, but work has not been done.
That is between the contractor and the government. The government will take steps. Whether the work has been done or not done, the government will do it. They can definitely rescind the contract, they can cancel the contract, they can do whatever they want. Did you find out? I could not. Wanted to gather.
Government of Orissa has expended much money development of civic area. CORAM.
Sir, have you made out a case of such nature that what is the public interest, what the public is there, what is the common, the general, I think the very important issues. You simply wanted to gather an evidence by virtue of this litigation that you have applied under the RTI. Can you use the PIL and in this way? I'm just asking you, there's show us, convince us on a proposition of law, we are there. But at least something has to be said, nothing is pleaded. What? Notice on this petition, then it will be a mockery of law. if not a mockery of justice, but mockery of law. Tell me. I read your prayer. I could not figure out what you really wanted to seek relief. There is no material, nothing has come out. So
It is thus Tripathi. Have you taken any instruction?
Yes, miss. And I have taken instruction in this matter. The annexure.
Perhaps this is the allegation that certain works are awarded for this for the area development, and different contractors are engaged. They out of 19, 17 are shown to be completed, or so, then money is also paid off, disbursed in favor of the contractors. But what is flagged is actually the work is not done, or substandard work, either of them.
how they do?
So-
Are you an expert that what substandard materials or something has been used? Are you an engineer? Are you aware of that? What should be the quality of the materials? Have you engaged any engineer to have a report? You are coming in a PIL. There should be some material which should be there. Mere saying will not do. If their stand is that they have completed the work, who will ascertain it without any evidence? Now is a oath versus oath. They are saying they have completed, you say not completed. What the court will do, whom to believe and whom not to believe? Both on affidavits. You have not produced any evidence that it is really of a low standard, substandard. Nothing has been produced by you. Some piece of evidence must be there. That we can rely upon that. Have you done it?
That so far this annexure to representation is concerned. After receiving that, Miller, I have got instruction that the district collector has directed the chief development officer of the district to inquire into the matter, Miller, and to submit a report.
Yes.
But thereafter, no report is submitted.
So that is of 25th of February. Now we are in the month of October. So nearly 7 months have gone.
Miller, the factual aspect is that, Miller, this annexure to was never given to the collector, Miller. It is only prepared to file.
It was never given.
It is not given. After
Show us that you have given it.
Miller, I have already given, and
Where is that? He is saying that it is not given.
postal receipt has
Where is a postal receipt you have annexed?
No, not that. AD. AD, AD, acknowledgement due receipt. No, this is not.
Will you not annex with the petition? Look at it, they are taking a stand that this letter has been manufactured for the purpose of this litigation. It was never served nor given to the authority. That's a serious allegations. And will you not annex any document showing that it was sent or it was served upon the authority? You are everything hiding in your pocket and then you are taking out. What we are these are the petitions do not deserve to occupy the space in the docket of the court. Unnecessarily you are litigating. They have already taken a step, let them take a steps. But this inquiry, when you have after this receiving the writ petition, then
Submit the postal receipt.
what postal receipt? Show us the postal receipt. Where is a proof of service? It is a proof of dispatch. Where is a proof of service? There is a distinction between a proof of dispatch of a postal article and the service of the postal article. Where is a proof of service? Show us. Unnecessarily. It's really a fancy litigation.
After copy of the writ petition received, you have
You said
directly.
that is what they do. Where is the postal receipt? Show us. Now, देखिए. We don't believe it, sir. We are taking on record and we don't believe it. Now, this is a high time we should. Your letter, the representation is dated 25 to 2025. That means on 25th of February 2025 is a letter. Your postal receipt, the date of dispatch is 14/5/2025, means 14th May 2025. That too nearly after three months. Or just nearly
that
3
means, my lord, after filing of the report.
Oh, wait. 14/5. Then, who has sent it? One Ranjan Kumar, OHC. The letter is written by Gangadhar Kaushalya.
You have sent it.
Miller,
I
have sent.
You have.
Will you not send it with your covering letter when you are a lawyer? Are you simply a dispatcher? You're a lawyer. Will you not write on your letterhead? And when the writ petition is filed?
12/5/2023.
12/5. And you have sent it on 14/5. That means this letter was never sent prior to the filing of the writ petition. Do you think that we should believe it? Sorry. That's all. some kind of such litigants, definitely. It is not you, it's the litigant who will suffer. It's not you. You have just moved the petition. No problem.
Item number 2.
Instructions. The date of election has been fixed to.
I have not understood what. Both of you started, I think. I am unable to understand what is the fact. What is the fact?
The inaction of the opposite party number 4 in eviction process.
Oh, unauthorized occupant of the garden.
Yes.
My instruction, my lord, is that the eviction drive, my lord, it has been fixed to 28th of this month. The notices have been given under the OPL Act, and 28th, my lord, we are going to evict them from this.
We are fixing this matter in the month of November, so let them keep it. Then they will tell us that the instruction petition.
Basic is the petition on the public interest litigation file for the development of the one Keonjhar district. Two districts are the mining affected area. One is Sundargarh, two is Keonjhar. Here in the Keonjhar, there is a huge surplus of money towards I have annexed that. So we get something at that ward may not be. district mineral fund. So they decided for maintaining of the livelihood of the local tribal affected area, they proposed a 15 crores for the beekeeping farming, Lord, apiculture farming.
This is the beekeeping.
Yes, Lord, because it will protect the environment basically.
Beekeeping will protect the environment.
Yes, there is a scientific the beekeeping farming, Lord, it is scientifically, Lord, say that if you there will be climate changing or they have research, Lord, I made a detailed applications and for this reason it was approved and one tender was invited in the due to July 2021. Thereafter, my lord, this project was not been implemented, and other districts, Sundargarh, it has been done.
Oh, in
That-
this district, it has not.
Exactly, my lord. That's why I have. My lord.
Just now I received the instruction. WhatsApp on that. Twice the tender was floated. One on 31/12/2021 and 5/7/2021. And on both the occasions, the tender was not successful because of the single bidding winner. And that was and as such there was no compliant to government procurement guidelines.
At that time, pandemic was.
Yes, pandemic was there.
Why you not take steps thereafter? Now we coming the normal situation. You should.
That
You should. I appreciate it that during those peak hours, at the peak time, the COVID time, there may not be adequate numbers of participants. But
now it can be done. Let me take instruction for the result for that agent. Next week, if I call it 1 week after, I can also speak to the district industrial sector.
I look. I look.
Item number 4.
Last time elected to take instruction. It's a board.
who's this? Public interest,
But I made a synopsis of the facts. May I pass on this?
There it is. One man can understand prior to how
That
the Red
is-
Court can extend its territorial jurisdiction. I do not know prior to, can we, if we cannot go beyond the state, can we go beyond the country? Prior to, tell me.
That is also again this one.
Show me one, any, where extraterritorial operation can be done.
Only last time they have directed to.
They did not.
I prepared-
read the petitions, but I do not know, sir, whether these issues which were not flagging,
I'm just passing on. I prepared a synopsis of facts.
not necessary. Please tell us prior to, you are a counsel, sir, advise us that we can pass a mandamus of this nature. Yes.
that-
Whether any
No.
court of the country can pass.
No, that is not.
So,
That was, it is drafted by the, I began saying, Lord, it is drafted by the petitioner himself.
so what?
Himself. So,
So why?
so I am now,
You are,
I have
you are
not
appearing,
prepared.
sir. Will you not
I know. I know.
share the responsibility? You
I,
have to defend the petition,
Ah,
sir.
yes. That's why in my synopsis of things I have written. So,
Sir, we go by your reading.
Pending on the footprint of 2810. Let me, well, there was to be decided along with that, this batch of cases.
TT. Now the
Pictures eligibility test, now the judgment.
Supreme Court
Yes,
has,
Supreme-
Justice
yes,
Bhatta has,
Supreme
I think he has already delivered a judgment.
Justice
It's mandatory now.
Justice Dipankar Datta.
That is what a Justice Bhatta I said.
Yes. But the read petition number 10430
What remains that on the basis
because
it is mandatory. One has to.
remains only the petitioner is governed under the old act. That is the he was
That was
he was-
also, that
that
was also argued
also-
before Justice
but
Bhatta.
only I have to
Timely line was given, I think 2 years they have to qualify.
Find out the
Yes,
law is
within 2
prospective.
years.
The law is
Within 2
prospective in nature. There should be a lordship decide along with this batch of cases 2010-2020.
No, sir, there are two aspects because
Yes.
if I correctly remember,
Yes.
if my memory does not betray me. I think this was also argued that what would happen to a already in-service teachers who did not qualify. And I think the timeline was given.
But because only I have to so
Why you are afraid, sir?
When-
2 years time is
No, during the pending-
is
and during the pendency of this case, this judgment has come matter.
that's-
Now, because the only we have to only your proceed to decide whether that is the law, that is the which govern the
I'm telling you, I appreciate it. When you say that the law should always apply prospectively.
yes, proceed the
Unless,
general
unless it is intended to apply.
yes.
Prospective precedence and a retrospective precedence, we are conscious. But if the point has been decided by the apex court in a judgment, which concerns the point directly or indirectly, then in that event, that judgment has to be respected. It is because in the Supreme Court also, the plea was taken that what would happen to our teachers who have already been appointed
Yes.
and they are rendering services for such a long period of time. The Supreme Court says that no matter they do not have, we are giving them a timeline within which they will qualify this TEC. Then in that event, prospectivity and the prospectivity is gone, is blurred.
But here, there's some, like, there is a some that is the predicaments, there is the has not been, that is the appreciated by the Honorable Supreme Court, because some persons in the old age, at 25 years of serving, we might maybe put into the medical,
No, it's not a
because he is not, he or she is not able to qualify in the eligibility test, then he will, he will be terminated from the service.
No.
This should be decided, your lordship.
TET, they have, this is not a question. They have to qualify the TET. They have to take the examination.
Examination, yes.
That's all.
Yes,
Nothing more than that.
That examination means they have to qualify. It is a TET.
Correct.
Qualify. Because if he is put into the medical.
Can we
Yes.
go beyond the Supreme Court judgment? Because by virtue of Article 141, we are bound by that judgment.
She will decide in the batch of cases along with this.
You do it.
28.
Please bring that judgment or give it that
Yes,
judgment.
I have also bring the judgment also. My lord. It's everything. And in WPC number 10430/2024.
Let it be added. When that matter is listed.
28.
So along with that.
Like the 10430/2024 read petition on 28 where also decide on.
Please. And bring that judgment of Justice Doctor.
Judgment. I have also.
Please.
Lordship.
Yes, give it a. You keep it. I think I wanted a. 214 and 15
Yes.
are very clear. Can we go into the retrospective operation of it? We can't go into the
Mr. Rathod,
retrospective.
Have you seen paragraph 214
14 and
215?
Answer.
That clinches your argument. Nothing remains. So can we reopen? or
Can we
open this?
decide a retrospective operation? We can't.
Your Lordship will not only, your Lordship will say something because the petitioners have been working since
Correct.
pretty long, 25 years back.
Correct.
And now they have become old, my lord, and now they are put into the hospital,
Uh.
and they are not unable to give the TET examination.
True.
And unless until they qualify the TET examination, they will be terminated. They will be ousted from the service.
Correct.
That has not been decided by.
That is what is decided, sir.
Yes, your Lordship.
This Roman 8 is order on applicability of the TET to in-service teachers.
Yes.
That is your case.
Yes.
214 says, per the details discussion above and resting on the same, we hold that provision of RTE Act have to be complied with
Yes.
by all schools as defined in Section 2N of the RTE Act, except the schools established and administered by the minority, whether religious or linguistic, till such time the reference is decided, because the status of 29.2 of the Article 29.2 was there, and subject to the answers to the question formulated in Section 7. Logically, it would follow that, now I am reading very slowly, in-service teachers, within bracket, irrespective of length of their service. Now, when you are talking about 25 years, 30 years, bracket closed, would also be required to qualify TET to continue in service.
Yes.
Then, however, we are mindful of the grounds realities as well as the practical challenges. There are in-service teachers who are recruited much prior to the advent of RTE Act and who might have put in more than 2 or even 3 decades of service. They have been imparting education to their students to the best of their ability without any serious complaint. It is not that the students who have been imparted education by a non-TET qualified teachers have not shown in life. To dislodge such teachers from service on the ground that they have not qualified the TET would seem to be a bit harsh, which you are arguing. Although we are alive to the settled legal position that the operation of the statute can never be seen as an evil. Bearing in mind this predicament, we invoke our powers under Article 142 of the Constitution of India and direct that those teachers who have less than 5 years of service left,
Yes.
as on date, may continue in service till they attain the age of superannuation without qualifying TET. However, we make it clear that if any such teacher having less than 5 years service left aspire for promotion, he will not be considered eligible without having qualified the TET. Then, insofar as in-service teachers recruited prior to amendment of RTE Act and having more than 5 years to retire on superannuation are concerned, they shall undergo an obligation to qualify the TET within 2 years from the date in order to continue in service. If any of such teachers fail to qualify TET within the time that we have allowed, they shall have to quit service. They may be compulsorily retired and paid whatever the terminal benefits they are entitled to. We add a rider that to qualify for terminal benefit, such teachers must have put in qualified period of service in accordance with the rules. If any teacher has not put in qualifying service and there is some deficiency, his or her case may be considered by the appropriate government upon representation being made by him. Now, after that, can we go into that retrospective or prospective?
Last part, this is a prior to amendment of this RT.
Sir, this is what it says. It says that a teacher, the very sum and substance of the entire judgment is there. First thing, RTE Act mandates TET as an eligibility qualification, which is mandatory.
Yes, yes. My lord.
Have.
Sir, commencement of this act.
I am coming.
Yes, yes.
Don't worry.
No.
I am going one by one.
Yes.
First thing is that RTE Act mandates the qualification to become a teacher, the eligibility test, that is the teacher eligibility test. First criteria. Second is no appointment can be made after RTE Act came into force in respect of or to the post of a teacher unless the person has qualified TET test. Correct. Now, third, that in-service teachers who were appointed prior to coming in force of RTE Act have to qualify TET test first.
Yes.
Exception is that only those teachers who are going to retire within a period of 5 years from the date of this order, then in that event, they need not have to.
Here it is a distinction.
Please.
My lord.
They need not have to qualify TET test. And they will continue in service and retire. Again, if they claim any promotion, then in that event, they have to qualify TET. Otherwise, they will not claim promotion. Thirdly, any teacher having no TET qualification, having more than 5 years of service, then in that event, they have to qualify TET within 2 years from the date of the order.
My lord, is it 5
If
years?
they do not,
Yes.
the consequence is also provided, sir.
5 years.
If they do not qualify, then they should be removed from service,
Yes.
either by way of compulsory retirement, by giving them a terminal benefits, and then also giving them a pension, provided they fulfill that particular qualifying service period. In the event they are not, then also the right is given. They can approach the appropriate government and can make the prayer. The appropriate government was given the full discretion to decide those what to do and what not to do. This is how the crux of the matter. Now you tell me what is the point.
I bow down the judgment of the Honorable Supreme Court. But Supreme Court, there is a
So we also.
Here, Supreme Court has also discriminated. Why 5 years?
Can we say?
Why 5 years?
I am asking you, sir, can we say
That's
as a high court, because of Article 141, can we say anything?
Yes, your lordship will decide in this line.
No, can we say?
It's on that.
If the Supreme Court has said, can we say that this is wrong? We can't say that.
That's
We are
why
bound by Article 141.
Again, we
sir.
have to, so they are also.
You go there, you go there. What can be done?
This is the thing.
We are deciding it
Very
here on the basis of this judgment.
My lord, only 2810.
No.
Your lordship may decide on 2 p.m.
What for?
2 p.m. my lord. Everything will respond. decide everything, all.
We are dictating it and it will be dated on 28th.
28th.
We are dictating it.
All right, when.
Yeah.
I got it. Only may do pay me.
What remains,
God, I know that, my lord, because during the pendency of this writ petition, during the pendency,
open and shut case.
and
That
during the
judgment,
pendency
so
of
far
this
as that
case,
judgment is concerned, there is no dispute, my lord.
Ah.
What is the problem here? That the service of the petitioner is governed by the elementary cadre rules that of the state. The elementary cadre rule was amended in 2019,
97.
granting exemption of TET to the teachers who were appointed prior to 11/2/2011. Now, the virus of that statute is the subject matter of challenge in the batch of writ petitions which your lordship have posted to 28. So that particular cadre rule, their service is now governed by the cadre rule, vis-a-vis the statutory provision as provided under the RTE
No,
Act,
because RTE Act is a central legislation.
central legislation. So that repugnancy has to be decided by
So
the.
that any subordinate rules or subordinate legislation which offends the very core, I think the ethos of the parent act. Can it go? Can it continue? Fine.
And the central legislation was also amended in 2017, granting the teachers liberty to acquire that qualification
That was
within
a
a period.
5 years.
5 years. That was. But 2019, the elementary cadre rule amended, granting exemption. So that is why the virus is under challenge.
Sit with your students. Pass out the class 10 examination or class 12 exam.
Yeah.
Sit with them, but teaching them and then say,
because there is something we have to approach, because there's some discrimination and some predicaments. That's why we have wondered what I have allowed.
I have not come across any
Yes,
judgment
yes,
of law.
Yes.
That a judgment of the
Yes, yes,
court
I-
can be said to be a discriminatory in nature.
Yes,
And
ma'am.
I
Yes,
quote
ma'am.
where that picture is.
Virus has not been challenged. Only application of the central legislation is the subject matter here. But he has enclosed that cadre rule. He has.
Virus has been challenged, that is a 23.
After perusing the
and passed on subsequently, list of citations also. This is relying on that Golden Das Bhanji 1952, Supreme Court Commissioner of Mumbai, and also Mohinder Singh Gill.
I dictated the order,
Mal.
but in the midst of the order, I think some disruption was made.
Essentially, the issue is before my lords in both the markets, the common issue would be release of 2 trucks by IOC. If these 2 trucks are released, that can be produced by me before the
Replaced by better and
short point.
better.
I started the dictation, I think
Bigger.
I could not complete it.
So
within a time.
can it be?
Bigger and higher capacity.
But I may pardon me, Lord. I have filed one case a year ago that tender matter, and then notice has been issued and the counter has been filed. In that case, though I am the last bidder, but I have not been given that 2 trucks under same MS. That may kindly be taken up with this case.
Why would be? That is a different issue.
But the
That is a
issue
different issue.
issue is there, Lord. Since they have given the trucks.
Here, if I correctly remember, I started dictating where we said that they were awarded the contract, they were continuing with the contract, they disclosed the number of the trucks.
Yes.
No.
They say that what should be the capacity of the trucks. Everything was there. It is not that they have withdrawn it. Only thing is they asked for release of those 2 trucks.
Replaced by better.
There are 2 letters on a very next day. 2 letters. One, they say that they require a thorough repair of those trucks. That is on 31st,
7.
whatever. And on the very second day, they wrote that please release those trucks because I wanted to participate in the other tender. That was ultimately allowed
Yes.
on the basis of the latter one, not the earlier one. Latter one. But subsequently, the authorities proceeded to cancel it. And citing a particular clause, which we have to consider whether this clause has any applicability.
That's
in
That's the point.
Subsequent clause.
because they are taking a plea of a particular clause.
Right.
Interpretation of that clause is the important factor,
Right.
whether it applies or it does not apply.
Yes.
That's the.
Because they offered a very, the truck of a recent make,
Recent make and
having
higher.
a larger capacity.
Yes.
Whether they can do it. Mere intending to participate in another tender is the, whether that clause is attractive.
That may not be disqualified.
But my lord, at the date of that applying laws, they have not obtained their NOC. So whereas
How is it?
it is our own truck. We have offered our own truck, my lord.
Sir, that is a different issue. That is the subsequent tender which they have participated. We will decide it differently. So far as they are concerned, whether this order of cancelling that particular no objection certificate,
Yes.
whether that is justified on the basis of a particular clause of.
Yes,
That is the
that's
That's the only thing.
short.
I remember, I do not know, I think because of the paucity of the
You are not directly covered by Supreme Court judgment, your lordships.
What Supreme Court? You have cited a Supreme Court judgment having no application.
No, it's Mohinder Singh Gill. Mohinder Singh Gill was the judgment, and
Mohinder
also
Singh Gill
that is
is-
based on 52 Supreme Court, my lord. That is based on 52 Supreme Court. That is
Just give me
the original.
I will complete that.
Well, in our case, we have also given the judgment, stating that
Consider it.
Let him not conflict.
Later on.
Whenever it matter comes, your lordship will
When
decide.
that matter will come, we'll decide it. Just give it to me.
that matter may carry to time of tomorrow minute. That
Yes, first, sir, dictate the judgment, then tomorrow. Don't pressurize us
no, please.
to do it today, sir. You are putting a pressure on us. Wait, have.
Yes, yes, well.
Great.
Item 7.
Submitted matter, I file my counter affidavit.
The same thing they have repeated. The same thing they have repeated. I have seen that. Once your lordship decides this, automatically.
Taken on record, that is the only prayer.
Yes.
Great.
Item 7.
I plead your lordship. This legal agreement was here between the petitioner and the opposite partner, two minor branch manager, Allahabad branch manager.
Can we compel a party to limit the premises on lease rent? Sir, it is within the discretion of the authority whether to take your property on lease or somebody else's property. Suitability is one of the factors. You say that they are operating on the ground floor, why they will not take on the first floor also?
They have issued Annex 2 mile, they have issued advertisement for tender. I am the lowest bidder, my lord.
Maybe.
But instead, 1 year already has been passed, my lord. Instead of finally the
Give
tender,
a notice to the bank. In the
my lord,
notice to the bank. Let the bank.
my lord.
1 week. Maybe in the second week of November.
Yes. Item number 8.
This is regarding that possible encroachment and blockade of public road. My lords expressed the lord's concern and Lord State Council, Madam Knight, also I understand has rightly apprised the ISC, whatever police of Bhubaneswar and the Commissioner of Police and the collector. I am surprising manner can find this order my lords for adoption was made seeking instructions on 22nd last. And my prayer before my lords was that to prevent them from again staging the blocking the public road on the occasion of a Ganesh Puja. But they did it, and with the full assistance of the police. And unfortunately, man, so police is providing barricades, putting the barricades on
What
where
are you doing, sir?
But kindly have a look at
There is no difficulty. You want to organize a community figure or this one. There's no difficulty, but we have to give a passage. Yes, what we have to give at least from both the sides, there should be a passage of at least one car can move.
there are other places my lord has seen, observed my lord, have seen there is a place, the earmark kept by the government land, and that is just by the side of that road. They can own 1 acre of land. They are using that for control. Why can't you block the road?
The last paragraph, then will have to give access. You can't block it. Somebody has to embark. And in case
more than
of an
10,000.
emergency, what will happen? At least one vehicle must be allowed to pass through.
Alternative routes are available.
Sir, alternative routes, if they have to embark 3
I'm
kilometers.
sorry, I'm
3
sorry,
kilometers
for a moment, my lord.
which is at the arm length
Oh my lord.
distance, then
I'm sorry, my lord, to interpret. They have said that the alternative is a law. I'm sorry to say, I will great respect to
Last paragraph.
false.
They have admitted. In last paragraph, they have
Problem.
admitted.
1 second, kindly have a look at page 23. 1 second, kindly have a look. Photograph or question.
Please look at the last paragraph.
And how can we say that?
I invited your attention, sir. I know. That's why I invited your attention.
My lord's concern that they, so looking at the very photograph itself, other
Not photographs. Their admission is also there.
yes, man.
What to do?
It is
What is the width?
But I have to take further instruction.
Further instruction.
The weight, they are not put in ground.
my humble submission is
My suggestion is for the honor upon it. My suggestion is that yes, these are all, it is being held for time immemorial. It is not a 1 year
hot future.
or time immemorial.
Yes,
It is being used
that is why
since past several decades.
that is why I have approached you.
No, several decades. Only they have said that all the residents of the locality have liberation. Rather, they are wholeheartedly except you are raising an objection. Definitely, the right to access is definitely ingrained into the system. There's no debate. Only thing is that what modalities can be suggested. Problem is that access, that your access is blocked. If by any means the access is given to you,
Access is right, absolute. Oblige, my lord.
then in that event, I think there should not be any problem in this regard. So we have to embrace the culture, the traditions
I'm
of
there.
our society.
I'm there for a moment, my lord.
So what I am suggesting that if we can say that at least one side, there is a space which is given for the purpose of any motor to plant. Motor to plant. Then in that event, at least the access is ensured to you. And these are of a momentary or a temporary in nature for
Well,
days,
10 to
days.
12 days. But that will give a license to them. That will give a license. I'm trying to
You have endorsed one newspaper reports.
pardon me.
You have endorsed one newspaper report. You have
No, not
endorsed.
these photographs.
You have endorsed one
Yes,
newspaper
yes,
report
yes.
that does not reveal that the road is blocked due to this pandal. But the problem is with the parking space. It is not,
Participant. Oblige.
it is not the pandal.
Oblige.
Pandal.
Then how can you park the car on the road?
On the road. That's a
How
problem.
can you park the car?
That is, but what this is, the last paragraph. So that seems that this parking, but the congestion is there. Because vehicles are parked alongside.
That we will
Ah.
ensure that no parking is there.
When
That
participant,
they have to come forward.
I'm sorry,
To state that.
participant,
You do not permit any parking of the car on the road. They are not separate. Under the Motor Vehicles Act, that I think, if I am not wrong, there is a rules which says that you will have to have the dedicated parking within your premises. You
See
can't
that-
park the car on the road.
That
cannot
means
pass. 10,000, more than 10,000 people, how can they communicate, my lord, there and if they block part of the road and keep it, the entire person, as my lord, Mr. Raman suggested, said, observed, entire participants observe the melody and the orchestra standing on the road. And police comes, put barricades, can have a look for a moment, my lord. I'm filing this additional affidavit.
Sir, have you ever been in Cuttack City?
Ma-
For 6 months, I think,
My lord,
for 6 months, it is perennial problem in Cuttack City.
that my lords have taken care of this is my lord, this is how was.
Where is the judgment of the
That you
Calcutta?
can't
Where is
hold.
the judgment of the Calcutta High Court in this regard?
That I
I think that was
have
the there is a judgment.
I have not laid my hand.
Please, there is a judgment.
Can I get any reference?
There was a judgment when during this Durga Puja, there is kind of a PIL that came. And then there was a modalities which was suggested by the court that what is required to be done. So if I correctly remember that it says that you can't because a right to profess religion is also a fundamental right.
Yes, ma'am. It comes.
Right to life. Right to life is also a fundamental.
Yes, ma'am.
Now, when there is a conflict between an individual's fundamental rights and a collective fundamental, then which should prevail?
Fundamental right to freedom.
I'm asking, which is that if large section of the societies, they embrace their fundamental right. And then one person thinks that this fundamental right is infringed, that if those conflicts come, then what should be the real approach by the court?
My only concern is there is an alternative to have given photograph and that we gone out. They can hold it. We have no objection.
Problem, I think, hey,
Last order towards the page this is 9/20/2000. Yes, my lord. Last location, my lord, directed. Complaints of the.
oh, this was that you
Yes,
raised
yes,
the
yes. I am just-
suggestions and all that.
Come with all the records and I
And despite those suggestions or providing an hearing, they have to sit in.
Right.
If I correctly remember.
Yes, if your lordship looks at the first tender has been issued before the document was finalized, in fact. The apex document has not been complied with. I'm just like this. I'll not consider my clarify that happened. And it is a case where the tender was protected by the East Coast Railway. And the OP number 3, what record is relying upon by Nayan Senior, that is the organization in independent nature of the railway, those a research organization that is called RDSU, the Research Design and Standard Organization. What is that one? They are only make a research about the different engineering or any setup is there. And they, the regulatory body, they will advise the concerned railway, East Coast Railway, Southeastern Railway, any railways, that this is our guidelines. You will put in the tender in that basis. And what happened in this case, there the document relied upon by them, that was the letter issued by RDSU, not by the engineering. It is completely two different organizations. That's why they have instructed their asked me to take a time for RDSU. There is a separate council affair from our place. And they will give the stand that they have a separate resolution. They have given scope to everybody to give their suggestion. And they are also given reply to them. That according to your question, this is the answer. This is the answer to that. That's why the document they have provided, I could not file my affidavit within 7 days. Will file it. This document clarifies that the RDSU has made a communication on not only 3, they have given 17, and they have 12. And out of which Khemchand is one of the yes. And let's see, I'm documented.
Which page?
This is the minor city.
No, you are serial number 11. That is the persons who submitted their comments and suggestions.
Yes.
You are there at page 2, serial number 11.
Yes.
Then
Then let's see may come to this bunch of documents I provided. I could not file the document affidavit because of this. Then let's see the bunch of paper. Next page, let's see. That is the first page onwards. Let's see. Reply on the firm's contents, observation, suggestion on procedure order and technical eligibility criteria of the PAUT. Were testing for the testing of FB welding joint services meeting such and such 6/6/2022 RDSU. The next page let's make up. This first page last line let's make the Khamcha. He is the petitioner. He has made a query to the RDSU. He is well known to that this engineering is completely different, protected by the different. It is a different organization to whom he has given it. The new technical, this is his question to this RDSU, suggestion to the RDSU. Then the next page, the RDSU, page 16, let's see, in last way, reply to Khamcha. RDSU has given to them. Page 16 में sorry my lad, I could not able to there with this.
They have given a full reply that there is no difficulty because some of the countries are using, but it does not mean that the other method is a faulty one. They say that we have been using in our country, these are the methods. So the suggestion may be valuable, but they have not accepted it.
The infographic looks at page 72, 4.4
In 72 of the.
of the rate petition.
Let me complete. Let's make this small bunch of documents. Let's see, we see the 1/10/2025, page 11. Page 11, communication. May this page 11, let's see the letter issue.
These are the issues which we have received. Number 3, detailed replies have already been given in annexure 1. This is what you want to reply.
Yes, ma'am.
It is given.
Yes, that is, let's see the first line. All SRP and DRT approved manufacturers, agencies having RDSU approved QFE for the outsourcing and other agencies. That means this meaning of the SRT is single line and single real tester, and the DRT is the double real tester. This is two method of testing. We have given scope to everybody. The single line or double line, whoever may be on the tester, we have given we have maintained transparency. Whatever best solution they are giving, it is also taken care of and also given reply to everybody. This organization has done so. After that, the East Coast Railway come and come forward to putting the tender. Not only East Coast Railway, the other railway also completed the same, and they have also started their work. Because the railway is going very fast and every day this new trends are come up. and speed trains have come up. That's why technology has been developed and where developed method has been utilized.
May I
For
just
the safety
indicate
man.
one thing, also permit me, but what my friend says, 1/10/2025, a letter has been issued after the matter was taken up for hearing before your lordship. 1/10/2025.
That is the RDSO, not the, do not be mixed together.
Sir, just a
RDSO is a
minute.
different organization.
I got your point. You say artist is a different.
1/10, it has been issued. If your lordship looks at 4.3 and 4.44, page 72. On third, there has been no meeting, as your lordship rightly indicated in the order. The four has not been complied with. Prior to compliance to that, the tender has been floated. And you look at 4.4 method. Page 72. The member secretary of the committee shall then prepare a document containing all the suggestions, comments received for preparation of written document. The document shall be circulated to all the committee members. Committee members may give their suggestion, recommendation on document in next 15 days. Member secretary will hold a meeting with the permission of the chair for arriving at majority consensus. Based upon outcome of meeting, minutes will be drawn. Based on the accepted changes, reason document final draft conduct will be prepared.
What I wanted to know, these are the documents.
The document they have filed.
72.
Yes, madam, page 72.
72. These are the documents with regard to what? With regard to an RDSO.
Preparation of the procedural order.
According to him, is the recommending body.
Yes.
The recommending body. It says that there will be a suggestions and everything will be done. But so far as the tender issuing authorities are concerned.
Yes, ma'am.
If they have issued the tender with certain specification. I do not know whether the decision of this RDSO is binding on all
This
the.
binding is the apex body, madam. They are the apex body.
The only thing is only the apex recommending body.
So there, if Russia looks at that, they have the tender document is mentioned that they are relying on this. Right, procedural order.
Show us. Because this is the document which I find.
You start from 60.
Connection for.
Pages, madam. I'll show 2 pages, madam.
Page 68.
And we look at page annexure 1 to that document, annexure 3. Page 47.
Page
47, madam.
Yes.
Procedural order for testing of flash bar welding joints.
No, this is annexure 1.
Yes.
The new textbook is.
Annexure 1 to annexure 2, madam. This is annexure 2 is the main document. The railway has accepted this. Soft copy of the procedural order technical eligibility criteria is annexure 1 and 2 at page 44. Sorry, page 44. Page 44. Based on this annexure 1 and 2, the tender has been floated. The reason being, and you look at page 54, madam. Page 54 is annexure 2, the procedural order guideline.
No, this is the letter which is issued by the Research Design and Standard Organization.
Yes, OP number 3.
Organization says that the railway board, by its letter, has approved the procedure order and
Exactly.
eligibility criteria for testing of the flash bar
Yes.
welding joints by phased array ultrasonic weld tester. That is the PAU.
Yes, madam.
T.
So this procedural order is Article 1 and 2.
Our advice for adoption of those things. So now they are adopting this.
So they are adopting this, but this procedural order which is being adopted is not final.
No, that is why they say that after the suggestions are given,
Yes.
after everything is taken into consideration, the final draft list will be published.
As per 4.4.
In the particular website.
Yes,
And thereafter it will be removed after a certain time.
exactly. 15 days.
Everything is removed
Right.
by this time. Now your contention is that before that decision is taken,
Taken.
they have floated the contract. Now it appears that the decision has already been taken.
So that decision has been taken on the basis of
only
a
thing
draft.
is, now the final draft list and everything procedure has gone. So only thing which is left
No,
is,
procedure has not gone on it.
the only thing left is that instead of this proceeding with this tender, they can float tomorrow the new tender.
Exactly.
Correct. So it will be only giving a new color or a
Sir,
new get up.
Sir, actually, this only takes a technical part. If your lordship looks at page 54.
No, what is troubling me is the judgment of the Supreme Court.
But here, if your lordship looks at page 54, and have a look at page
That is the
54.
Raptor cost branch versus Ganesh profit.
Now, here actually what has happened, what they are trying to float a tender before it is finalized. They can't do it,
Now
man.
it has been finalized. What I am saying,
So it
that
has still been finalized, man.
judgment I can now lay hand with to you.
But
To you is definitely from a civil side, that judgment. The suit was filed by a unregistered partnership firm for eviction of his tenant. Section 69(2) of the Partnership Act,
right.
that comes into play. A plea was taken that the suit is not maintainable because of the embargo or a bar created under Section
69(2).
It appears that during the pendency of the suit, the registration was
Gets registered.
Then it happened, they says that at the time of initiation, the
Defect was
defect, it is incurable, it is not removable. So the suit must fail. It went to the Supreme Court. The Supreme Court in 5 paragraphs has said that what would happen? I understand. I appreciate the point that initiation was bad.
Right.
There was no difficulty.
Correct.
If I say that the suit has gone, then what it will invite? It will simply invite a fresh suit. Same thing, same
Correct.
evidence, same witness, everything will be said.
Right.
It will be giving a new getup, nothing more than that, new number, new year.
Correct.
And therefore let it continue.
Absolutely.
If taking an analogy, what you say now, everything has been done.
Right.
All formalities are there,
My-
everything is there. If this tender goes, what would happen? Tomorrow the same tender,
Here there
with
is
the
a catch,
same
man.
thing, everything will
So
come.
here there is a catch. Here actually, if your lordship looks at page 54, your lordship will visualize that. Page 54. I'll just
Because I
show you.
read 4.3, 4.4.
Sir, can you look at page 54, madam? Not 4.3, 4.4. Here actually the procedural guideline has given this procedure has to be followed for testing the equipment, madam. Technical eligibility criteria.
Yes, true.
This has been depicted in the tender document.
True.
Sir, this has not been finalized.
This has already been finalized
No,
now
sir.
by virtue of these documents.
No, sir, that document is not final.
They have already sent it.
Sir,
Have you published it on the website?
No, sir.
Yes, my lord, everything is transparent, everything is published and it was finalized, implemented in all the
stage has also gone.
No, sir.
Ah.
Sir, if you looks at the document, it's not so.
So let them file their.
My lord, another 2 cases there.
Sir, kindly.
Now, if you consider the pair number 1, my lord, as a can interfere and partnership order.
Now,
As far as the
4.4
other pair is concerned, that India will look need to file his petition because the RDSO is notified in Lucknow. This other court have a jurisdiction.
Your suggestion, whether accepted or not, does not give a legally enforceable right.
Sir, we are challenging that the
Put
procedural.
it on them. Put it on evidence.
Yes, yes, we'll file a call. Yes, ma'am.
The provisions. Let them put it.
Yes, yes.
So this is a service provider. Can I just suggest one thing, ma'am? Subject to result, if they will file within a week, you have to hear this matter and dispose of it.
That's true. We are giving them a week's time because we have all the documents with them. So
Right.
You can ready within.
And that is also not final, man. I can show you or see. Because law has to be, if a person knows, it has to be followed as provided in the provision itself. Not, they cannot follow it. There is no other mode or modality available to them.
No, we are in a different
4.5 have not been complied with till now. Till now, it has not been done.
I think this client is not properly.
And this letter has been communicated only after you have entertained the read.
that troubles that judgment. That's why I say.
I understand already.
That judgment ultimately says that what if everything has now been complied with.
But on third incident,
It will give
Right, in fact,
only
was
a
identical-
few days, nothing more than.
Identical question of section 69. I myself conducted a.
again I am clarifying on instead of
point,
third,
sir.
it was circulated and sixth
Sir,
it was decided. Thereafter communicated on
What has happened? I filed a suit for enforcement of a right under section, before it is registered in section 69. Interim order was passed. The other side was Justice Arvind Patnaik. He was a lawyer for the other side. That is Tata. So they objected this. Court said it's not maintainable. So we challenged the order in appeal. In the meantime, we got it registered. And we filed the registration certificate of the court. The order was maintained.
Order was
Maintained
means.
means they sought to be held to be valid.
Oh. No, that case was argued by me before the High Court. So I took a plea that it is not arising out of a contract. Section 69(2) talks about the arising out of a contract.
So there is
I say it's not arising out of a contract, but arising out of a statute. Because the eviction is sought under section 111 of the Transfer of Property.
EPI.
So that is arising out of a statute, not arising out of a contract. So 69 does not have any application.
So that has been clarified with the subsequent Supreme Court decision.
So the Supreme Court appealed that
Yes.
in Dr. Cos Pratt. That judgment went to the Supreme Court and ultimately it was admitted. And ultimately they have decided. It's a very classical judgment, one has to read that.
To what extent it suit can be filed, that is clarified. You know, subject to result, if you say.
well, I am objecting to the tender was
Give him 1 week. Yes.
Let's me fix a date for it.
Yes, we have to, sorry, sorry.
Before that. Well, on 22nd, I have some difficulty. No, you should fix it.
Then it will go to the other base.
No, you should fix it.
So it is, yeah,
27th.
27th?
Any day you should.
27th. It is open to the petitioner to file rejoinder if any. In the meantime.
That is. Matter fixed for 2 p.m. hearing, item 43.
Let us see Dr. Singhvi is appearing on this.
Whereas we are here before your lordships, whereas your lordship is also awaiting, I believe, the counter.
Yes, today we are filing the counter in the WPC number.
Yes, whereas we have received no counter till now. WPC is 22431.
Today we are going to file, we are not filed. Today we will file in 22431 of 2025 in Tata Steel matter. And other matter, state might have filed the counter, we have not received the copy.
Your lordship has only got a declaration of intent after 2 months, whereas not an actual counter.
Maybe whatever this could do, my lord.
It's a good declaration of intent.
So today we are filing. So we will serve the copy to the other side and
State is not filed. And the state is not even making a declaration of intent.
Now, what to do? Tell me what to do.
Well, your lordship may give directions for whatever 2, 4, 5, 6 weeks to file a counter. And then within the time your lordship gives thereafter the date, we will file the rejoinder. Because I know your lordships can't go on without the counter normally. I mean, this is not much as your lordship would like to, but lordships cannot.
Adequate opportunity, just we want to ensure, nothing more than that.
Both have not filed, so lordship will have to give some time and then within the next time the rejoinder, whatever lordships.
State has filed counter in first 4 cases. And in one case, in respect of that we have not filed the counter, we will file in the meantime. But so far as the statute is in this, so this government has to file the counter.
What virus? Which one they want?
One of the
Rule 12A of the Constitution Rules 2016.
Yes.
So the vice of that is under challenge.
Okay. On what ground?
On the ground, your lordship, that the Act provides for corruption. On the Act provides for corruption, but the rule there is a contradiction between the Act and the rule.
So how soon you can file? Just tell us. So many matters. What to do?
If they are supposed to file counter in only one matter, other cases we have.
That you have to, say.
Yes.
You have to file memo adopting the counter. If you have filed counter in the main case.
In first 2 cases, we have already filed. Case of Tata Steel, that is the last matter, we will file within 2 weeks.
Where the virus is also challenged, huh?
Virus also.
So are you taking a different stand or taking the same stand? If you want to take a same stand when the virus is there, I don't think so. There can be a different stand in a different matter. so far as the virus is concerned. It has to be a uniform stand, whether you stand by the provisions or you say that this provision is offending the core value of the substantive act.
A demand notice were issued in lieu exercise the statutory powers. Now that statutory provision is the subject.
I think they are not challenging the virus on that ground. What they say, as I just heard from him, that if the Parent Act provides a particular mechanism to be done, whether by virtue of a rule, you can whittle down that particular mechanism and adopt the new one. Is a subordinate legislation, after all. The power is emanating from the parent statute. So that is what is the only, I don't think so there can be any different stat.
It's a rules which are state has no rule. Central rules.
No, these are the rules framed by them.
Central.
By central. Then what is your role?
That demand notice.
Just to appear.
Sir, I think
On a virus part, definitely.
you are for the central.
No, I'm reading the item 44, the public interest.
Very Mr. Pari.
Yes, my lord. We are filing the counter in the Tata Steel matters. Today we are ready. We will file today itself. That is in the 22431.
So please don't keep it in your office. File it in the court.
Yes, we will file.
Then you will file it. You are saying that I am having ready.
It is, today will itself. I am assured this court. Today will file the counter. And
Copy has to be given to them.
yes, other side will start the copy also. Yes.
Anyway, your lordship may have
Tata
to.
Steel case we are filing.
Anyway, your lordship may have to give it by the end of November because they will have to file a counter in the state and I will file the rejoinder. So everything can be merged together towards the end of November.
Dr. Singhvi, so far as the counter by the state is concerned, I think the state has a very, very minuscule role to play in this regard. So far as the virus of the Central Act is concerned.
For virus, my lord is absolutely correct. Your lordship's formulation a moment ago is correct. It is the virus issue between the regulation rules versus the act and not beyond that. But for the fact-specific issues, the state will have a role model. The counter will be very important.
Definitely. So far as the
Because on
demand part
fact,
is concerned,
etc.
at least the state has some
that's the problem.
defend.
That's right.
So in that event, first thing is if the virus goes, then the demand has to be considered on the basis thereof. On their own.
Correct, Manoj, but they will be in that sense.
If the foundation goes, then the castle can
yes.
stand on a... Yeah.
Absolutely, Manoj. The lordship is right. Only thing, your lordship, we want to take it up together in a holistic manner. That's all I'm saying. They want to file a counter.
Mr. DSG, at least you'll have to file it. I think one will suffice. I think you need not have to file counter in all.
It's true, my lord. Only I have to take a formal instruction from the department. That's all. Because the one case counter is
so far as the virus is concerned, we are concerned on that.
Yes.
Let us decide that
one counter is surprise the other problems also. No issue.
True. You have filed it or you are going to file it, Mr.
Today will file, man. Today will file. Everything is covered. Today will file.
19172, we have filed counter. Then the sub-item 3, we have filed counter. Sub-item 4, we have filed counter. And in last Tata Steel, we have not. This sub-item 2 and the last sub-item 8, we have not filed. We will file within 2 weeks.
What 2 weeks? You have already taken a stand in one of the matters. So I don't think so there is any special fact which you want to bring by way of a counter. Oh, that is demand notice based. The foundation is one. If the foundation in all the matters are one, you have to defend the foundation. So what is the difficulty in not filing immediately?
In fact, out of these 3 matters mentioned by my related friend Mr. Das, we have already filed rejoinder in first matter. Item 43, first matter we have already also filed, file is ready. Now third matter, today we are filing rejoinder. We have filed. We have soft copies also. So our part we have completed.
Lago, the batch of writ petitions.
High Court.
Batch of petitions.
Good enough.
Deeply obliged.
But come, it's an interesting point. Come on that day and argue the matter.
Come ready.
Mr. DSG, please also come ready on that day.
I will personally appear present before the court for petition.
Yes, call the next.
Yes, there is another expedition, identical matter, WPC 3003. That may also be taken upon board.
Sir, what is there? Why do you know if there are a lot of matters which are tagged together, it's very difficult to get it heard.
Very well. I'll leave it.
So let us decide. It will really
let others follow.
Impact the other one.
Very well.
I am also requesting my learned friend of the State Council to solve.
What is a sauce for a gander is a sauce for a goose.
Mr. Behra was something at some other.
What?
For other purpose.
No, you'll get it. Don't worry. We appreciate that. Don't worry.
Deeply obliged, Manas. Deeply obliged.
Yes. Yes. What is this item number 44?
Strong preliminary objection.
What is the matter?
Satisfy the test which is done for the R5 now, which is the private party in this case. Not two things. First,
You should appreciate the watchdog. You are against the watchdog.
the watchdog has been castigated by the Supreme Court recently, which has been covered by all the newspapers and bar and bench, etc. They have to ultimately withdraw that petition. And they have not disclosed that factor. That had happened prior to this filing of the hearing petition. Forged documents were filed in the Supreme Court. So that is on the credibility. But the more disturbing part is not that in this petition, they are saying that we have obtained orders from the High Court. Just see the language used in the petition. And a prayer is made to vacate a stay order granted in my substantive petition. Just see, Lord, can this petition be entertained? Just see, page C, Lord. Your Lordship, from the PDF page, Lord, 13.
Page?
This page 30, page C, Lord. The printed page C, PDF page 13.
1-3.
PDF 13, page C, otherwise.
Which one?
Page C, the Lordship has page C, synopsis. It starts with A,
Oh.
so A, B, C, the very third page of the petition.
Yes.
Meanwhile, CORAM
The bidder has insulated.
insulated itself through parallel writ petitions over and securing. So, this kind of a language is being used in a PIL as if your lordships are passing orders for securing somebody. Securing successive no coercive interim orders against crystallized dues, notwithstanding omissions and selective direction on court tender, MDPA obligations. Such duplicative proceedings constituted abuse that warrants vacation of interim protection so that recovery and enforcement may proceed. Now, this is not in the PIL. Then please see Lord and next page also. Page D, the very next page. In these circumstances, the petition raised for quashing the preferred bidder declaration and LOI declaration that option B's stand vitiated by the bid date ineligibility and post-tender for so-and-so, and consequential action, implementation of CAG's recommendation and fixation of accountability, vacation of interim orders obtained through misrepresentation.
This interim order is passed
in
here.
2021, and they are aware. Just see the list.
No. They wanted this. This interim order is passed in another
petition,
and
there
this is
an application there. They don't go to Supreme Court against that order. And in this PIL, they are trying to give an impression as if the High Court Lord is people are obtaining orders from the securing orders from the High Court. Now please see Lord in the petition at page H in the list of date. This petition is filed in 2025. Just see the list of date at page H. The petitioner, while its communication to the respondents, highlighted the inherent illegality of the bid submission by the respondent number 5, and see the date 9/2/21. So he is aware of everything since 21. Now please see the prayer he is making at page 131. Apart from Lord that in a tender PIL is not maintainable, Supreme Court has said several times. Just see the prayer at prayer R at page 135.
no stay order.
Vacate the stay order, so and so passed in writ petition.
I understand. I got your point. Whether in a parallel proceedings the stay order passed in an earlier, can it be done? I appreciate it.
Yeah, it has to be thrown out with cost, I would say, respectfully, because this person is, and then he relies upon the CAG report. The CAG says about 20 companies are doing some mining. He picks up one person. Supreme Court says you can't, if you want to say that the CAG is to be implemented, you say it should be implemented. You can't pick up one person and come to the High Court. So 21, he is aware, whatever be his case, I'm not wanting to get into the merits of this matter, whatever be his case, he is aware admittedly since 21. He knows that the no coercive first order was in 21, the second order is in 25, by two different benches of this court. He never intervenes in those proceedings. He doesn't challenge those proceedings to the Supreme Court. He doesn't intervene there. He doesn't disclose, Lord, that he actually has been castigated by the Supreme Court for having supplied, used forged documents by the same party. Because these are three watchdogs he has. Energy watchdog, this watchdog, and one more one. What is the third? Telecom watchdog. All three are doing this kind of activity. They are only basically indulging in Lord. And in the telecom watchdog also, CBI was asked to investigate their activities. So this whole business of who is this watchdog and what is the purpose, and if your lordship start entertaining this kind of writ petition, Lord, it will be actually, with great respect, Lord, he should have disclosed about the Supreme Court petition where he had obtained a.
So according to you, there is a suppression of the material fact that whether the PIL or the writ petition.
5 years delay. He's aware of everything since 21. He's filing in 25. Delay, suppression, and then your lordships in the rule have said, your lordship will recall when the Supreme Court was examining the PIL jurisdiction, it said every High Court should frame its own rule to see that frivolous PILs are weeded out. Your lordships in Rule 5 have very clearly said that before a PIL is entertained, the credibility of the person is to be examined. Now, if your lordships see the credibility, this person has no credibility at all. Lastly, let me assume everything, Lord, if you're not, as if this PIL could be entertained. What is the dispute he's saying? Whether I was eligible or not. There were 9 parties who participated. In a tender, global tender, 9 parties participated. 8 of them who were non-successful did not even make a complaint about my non-eligibility. All of us had the similar kind of eligibility as far as the manufacturing capability is concerned. What has happened post his whole petition is that the rule was amended post my award. Now, post-award amendment of the rule, he's taking as if I was not eligible by virtue of this amendment which happens later.
Whether it has a retrospective operation or...
No. The rule is not retrospective at all. The rule is bringing in 12A is bringing in a requirement of dispatch after my LOI. He's saying because of this amendment to the rule, my eligibility was not there. How can my eligibility be judged on a rule which is coming subsequent to the award of my contract? I will be bound by the rule subsequent, for which I am before your lordship, where I have got an interim order. But as far as my eligibility is concerned, will not be dependent on the rule which is coming later on. This whole petition is that, Lord. My respectful submission is, Lord, this should be rejected with exemplary cost.
How a subsequent enactment or the rules will have a retrospective operation?
Well, that is the related appeals, related petitions. The other writ petitions whereby they have challenged,
in this writ PIL, he's saying I am not, I'll just see that before.
No, that is what is the substantive prayer which I find, that you wanted a declaration that this particular lease deed which has been given be declared as the void or something. I had failed to comply.
Because I was not getting 12A, so I was not eligible.
Yes. Now 12A came when? After the tender was floated, after the lease was executed, or what?
Subsequent rule is with regard to dispatch requirement. What I'm concerned here is production requirement. My lord, this is the whole case.
You wanted that including Article 8 read with the Schedule D and Rule 12A1 of the Minerals, these rules 2016.
Exactly.
Now this, according to him, which I understood, that so far as 12A is concerned, he says that it came into effect or in existence after the tender was floated, tender was declared in his favor, lease deed executed. Then how can it apply retrospectively and then render that particular action?
I am not concerned about any retrospective applicability. I am concerned about
then why you are taking aid of 12A1.
MDPA is executed in 2020.
When this 12A, I'm asking you, when this 12A came into existence, tell me when it came.
20th March 2020. I was declared not successful
when
on 18 March.
When the tender was
March 2021.
2021.
I was declared not successful in February of 2020.
So prior to amendment.
1 month prior. His whole petition is based on
1 month prior to
that came into effect from 20th of March 2020. And if the tender is finalized prior to 20th of March 2020,
February 2020.
then in that event, can you apply this particular amended provision? That's the only point I just wanted to know.
My point is very, very simple.
Yes.
Under the tender condition, read with the MDPA they have executed.
Then what you were doing for such a long time, this tender was finalized in 2020 February, and this writ petition came to be filed in 2025.
Yes.
What you were doing for such a long time, 5 years.
I have written to the state government, they have not responded.
Now tell me that since you have simply written a letter and then slept in a slumber, whether that would really negate that particular concept of a delay in latches.
My lord, after that, they have filed a substantive petition in which in 2021 an order was passed by this Honorable Commission and the Honorable Court, whereby the court has specifically directed the state government that they should respond. Since 2021 till today, the state government has not responded. In 2025, my lord, may I?
So you were just watching, as your name suggests.
Your lordship.
You were simply watching, sitting somewhere else.
Your lordship.
And then whether a state, that means you are taking a particular strategic the decision after the state discloses the defense, and then you will come up.
The state has taken
action. But why you were sitting tight for such a long time?
My lord, the state, may I make a submission? The state has taken action. They have imposed penalty.
True.
They have asked reduction in the production.
That is between a state and them.
Yes, I agree.
There is no difficulty.
My lord, I agree.
If they violate any of the terms and conditions, the state will rescind, make a re-entry, can cancel the lease agreement. No,
my lord, the state imposed penalties which they have filed a substantive writ petition. The state was directed to file a reply.
True,
Lord,
they did not. They did not. Let us go.
On the last occasion, this is what was demonstrated to your lordships. How since 2021, the state has been slipping over it.
True.
Even after the imposition of penalty, not a single penny is recovered since 2021. And not only that, my lord, the state
because
not
that may be a reason of there may be a reason of any interim or protective order being passed by the court.
In 21.
So,
my lord, may kindly
how can a state recover if there is a preventive order? Can a state defy that order or violate that order?
I must stay prior to that one. The state is not required to defy the order. The state is required to participate in the adjudication. The state is required to
Can a PIL lies to ensure the participation of the state?
Definitely not.
In a pending litigation?
Definitely not, man. But the PIL is maintainable when it is a larger question. And the larger question.
What larger question?
My lord, the exchequer is losing money, my lord.
True, but there is, sir, it is not that the state has not taken steps. The state has imposed penalty. The state has taken all the steps which is permissible in law. If the court has intervened and passed an order, then in that event, whether the PIL can come? I'm just looking at the threshold of its maintainability.
Madam, kindly come to the order passed by your lordships on the last occasion.
Yes, I have because I did not hear on 10th of September.
Next party.
Yes, sir. There is notice not issued, my lord. There is nothing stopped there, my lord.
Yes.
10/09/2025.
Yes.
The instant writ petition in the nature of PILs raises a serious concern not only on the execution of the mining lease deeds, but also the conduct and the action of the lessee in violating the terms and conditions of the lease deed and or statutory provisions,
correct,
which rendered him ineligible to continue with the mining activities.
Correct.
And therefore, all the documents which have been executed in favor of opposite party number 5 and 6 must be declared invalid in law.
That is what we just reproduced what you have said.
Yes. Please bear with me.
Yes.
We are given to understand that several other litigations, including so and so, filed by opposite number 5 are pending before this court.
No difficulty.
The issue raised in the instant PIL, in our opinion, is intertwined and or interrelated with some of the issues raised in the aforementioned writ petitions, and in order to avoid any conflicting decisions to operate simultaneously, it is desirable that the instant PIL be heard along with those writ petitions.
True.
The writ petitions are mentioned herein above are directed to be listed on 9th October. Therefore, the instant PIL to be listed on the same day. In the meanwhile, the state is directed to file an affidavit responding to the averments and allegations made in the instant PIL, and a copy whereof shall be served upon the Lord Council, appearing for the petitioner 3 days before the listing of the matter they have not filed.
Yes, sir.
Issue notice to opposite party number 5 and 6, making it returnable.
Because it was.
Sir, yesterday only I received the.
What is a procedure which the court adopts? when any observations is made in absence of any of the parties, that does not really denude them from raising a preliminary objections on the maintainability of the public interest litigations. We simply recorded what we perceived from the facts which you have pleaded in the PIL. Now they have come up and say that this type of a PIL is not maintainable. Are they not entitled to raise this particular issue? They are, because they were not noticed at that point of time. What we're saying is that can a PILI for these reliefs which you have claimed in this particular regulation, you have to respond to it. First thing is, can a PIL be used as an efficacious tool to set aside the order passed by the coordinate bench, to set aside the order passed by the another court? Can it be done? First issue. Second issue is, if anything which has come subsequent, any enactment, any statutory provision which comes subsequent thereto, can a PILI say that whatever has been done prior thereto will be rendered ocious, will be rendered redundant, will be rendered invalid without having its retrospective operation? How can it maintain? You have to just answer that.
May I make a submission? Well, the state has not filed the reply.
May not.
Well,
now it's a question purely on the law. It's a pure question of law.
Which I received last night. They have served me last night. The preliminary objection I received last night.
What preliminary objection? Preliminary objection is on the basis of the facts which you have pleaded. They are not relying on any new document. If they want to rely on a new document, I will prevent them.
They have made
as a preliminary
allegations against the secretary. They have made personal allegations against my institution. They have extracted newspaper cuttings, my lord. Where I'm carrying the order. The Supreme Court speaks only through orders.
Mr. Counsel, we are not going into those intricacies. Let us be very clear.
Yes.
On the basis of what you have pleaded and what you have prayed for, whether you can maintain the PIL. Just we wanted a response from your
response. Preliminary objection.
Please
allow me 4 weeks time.
What for? Preliminary objection.
My lord, kindly come to the preliminary objection. I will demonstrate, my lord. My lord, they have indicated they are relying upon the orders. Which order does not dictate, which order does not record so.
Sir, don't go, sir.
In the gallery.
There is one principle of law. A plaintiff has to proceed on the basis of his own case and cannot take advantage of the defense weakness.
Yes, ma'am.
You have to proceed on your own case, sir. Tell us your own case. Forget what they have taken.
That I will satisfy your question.
Please, on your case. They have not relied upon any document which they want. They have simply gone by the statement which you have made in your petition.
They have not gone by the statement, my lord. They have assassinated my character, left, right, center.
Forget about it. We are simply, sir, we are simply on that. If you come to page 131, that's the prayer portion.
Yes.
Tell me that the breach of the obligations under the Mining Act of an agreement including such and such and Rule 12. Now you tell me whether 12A has any application, whether Article 8 read with Schedule D, what is there? Tell me first, one by one. You tell me.
Yes.
Tell me.
Madam, kindly come to my annexure P1. That's my letter in compliance of both. Madam, kindly come to annexure P1.
Yes.
At page number 139.
Yes.
This is the letter my lord, I have written to the state government.
Correct.
A representation under Rule 8 of the Odisha High Court rules.
Yes.
So and so illegalities in auction, eligibility, post-award conduct.
Correct.
So on and so forth.
Yes.
We are a non-profit, non-political public interest society working on transparency and accountability in infrastructure, natural resources, public finance. This representation is issued pursuant to Rule 8 requirement, which require that before filing a PIL, the petitioner must first send a representation.
Correct.
When Rule 8 is extracted, kindly come to para 3. We therefore renew and consolidate our earlier representations, call for specific remedial steps, and place you on formal notice that failing an adequate response, we shall move a PIL before the Honorable High Court of Orissa.
Correct.
Earlier representation already served. 9 to 2021, a representation to Principal Secretary flagged illegality in bid submission of Narveram Power Steel Limited, flagging illegality in bids in the auction of Roida 2 iron ore block, specifically inability to meet the minimum production requirement, inconsistencies in specified end use, capacity disclosure, and post-bid attempts to treat Amalgam Steel Private Limited as an eligible captive plant. On 16/4/21, a reminder was issued seeking prompt regulatory action to protect the integrity of the auction process and state revenue. While we understand the department subsequently issued so-called demand notices to NPSPL on so-and-so, 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 effective enforcement has not followed. And interim judicial orders secured by NPSPL. No lawyer is there. Please bear with me. These languages may I not happily worded, my lord. I agree to that, my lord.
There are two words which are never contemplated.
In response to our specific eligibility, NPR representations has been made to.
Again,
NPR production is not in 12A. My lord, production has not come by virtue of an amendment. It is there from the day one, from the NIT,
Sir, you are going and claiming or raising a finger so far as the auction is concerned. After such a long gap in you, I am asking.
It's a reminder, my lord, of 2021. No, please, my 2021 letter is also P20. I will show you.
I am asking. After the 2021 letter, what you have done till 2025. I can understand that you have written a letter of 16/4/2021. Reminder.
May I read further?
After 16/4/2021, what steps you
May I read the letter further? The letter
I am asking
captures, no. Letter captures. I'm not
appreciate. Now after 16/4/21, what steps you have taken?
My lord, please. The next, my lord.
Yes.
The last is 3/12/2021, December.
That is a showcase.
Yes, by the state.
Don't take advantage of the authorities. What you have done,
my lord,
you have done only on 16/4. What you have done after 16/4/21.
My lord, that is exactly what I have stated. That by virtue of the above letters, you have taken steps. I am addressing to the state and have led to prolonged non-recovery. No reason response to our specific eligibility MPR representation has been provided till date. Sir, no reply or counter affidavit has been filed in writ petition civil number 1665. Despite opportunity being granted as far back as 9/2/2022, this is despite ongoing revenue leakage and the fact that underutilization of the mineral is creating artificial market scarcity. Following CAG performance audit report number 6/2024, highlighting sharp grade downgrades, misrepresentation of revenue risk in auction mines, including Roida 2, we submitted a composite RTI representation dated so-and-so to the Public Information Officer. That is 3rd July 2025, Directorate Mine, requesting quarter-wise MPR, MDR compliance data from lease commencement and asking what enforcement action has been taken under 12A of the MCR 2016 and MDPA. Core regulatory concern, my lord, eligibility under the bid. The NIT reserved the Roida 2 block for specified end-use bidders possessing an SCU plant in India. Minimum production requirement was given 80% of prior lessee's average production. It goes to the root by virtue of which the allocation happened, my lord. They could not have been granted. That is the response your lordships wanted from the state government. The state government is sleeping over it. My lord, please appreciate. 2021, my lord, they have taken steps for imposing penalty and show cause notices left, right, center. Then OP number 5 moves and files a substantive writ petition. Writ petition, they get a coercive order, non-coercive order. After that, state has taken liberty to file reply. They slept over it. 2024, I have written again. 2025, I am reminding, telling them the entire background. And yet, after apprising this to your lordships on the last occasion in September, I was led by my senior. Your lordships have issued notice and specifically directed the state government that 3 days prior to the next date of hearing, they should come up with the response. If not today, then when? Why the state is skipping over it? Even if I ignore R5 and R6, why the state is ignoring? Why they are hiding behind R5, R6? My lord, the state 50-year lease has been granted over mines. Somebody with ability of 2 has taken over mine which has the ability of 5 per annum. Yet, come back to the court, ask for reduction from 5 to 2. They have been imposed penalty. They have still utilizing that, whereas on the contrary, the production ability of that particular mineral resource is 5 for 50 years. And my state and the country is suffering in two aspects. State is losing revenue and the center and the country at large is losing the supply curve. My lord, the BIS price is rising because the auction, the lessees are sitting over and standing over mines operating not to its optimum capacity, for the very reason of which an artificial demand and supply gap is created and the prices are skyrocketing. That is the public interest litigation. Let the state come up with a response. Why the state is hiding?
Have you pleaded all these things?
Absolutely, all these things I have pleaded, my lord. That's my whole petition, my lord.
Where is the pleading of that such nature?
My lord, please, my lord, all my grounds, my lord, I spoken all the grounds.
Bringing that particular, the concept of the law of economics.
Yes, my lord. I'm
that where you have made out a case.
I'm grateful, my lord. I'm grateful.
That the demand and supply concept you have already introduced in the.
My lord, please, my lord, may kindly come to my grounds, my lord. My grounds start.
Grounds is a part of an affirmation.
The grounds
there is a distinction between pleading and the grounds.
My lord, after the factual narration, after the entire factual narration,
sir.
My entire argument.
Just give me a pleading. No,
my lord, let me not go to my grounds. The very letter, my lord. Please have my P1. My very letter at the very outset, I have told them, my lord, please see the demand and supply gap. Para 7, my lord, recent events necessitating intervention, my lord. Please. No reply or counter affidavit has been filed in writ petition civil number 1665 of 2021, despite opportunity being granted as far as back in 9/2/2022. This is despite ongoing revenue leakage and the fact that underutilization of mineral is creating artificial market scarcity. My lord, not me. My lord, please appreciate, I might have been given a flavor.
Is a captive mining or it is?
It's an end-use mining. It's an end-use mining. That is the auction. That is therefore, merchant mining is a different thing.
That is what I am asking. Then
Yes.
How it affects the market.
That's all.
If it is a captive mining, then it is for their own utilization.
My lord, there are two aspects. I said there are two aspects. One aspect, the state losing revenue, and the
state has already imposed penalty. They will definitely will not lose. They will definitely recover.
My lord, the second aspect is they are free after 2 years. This 80% they should produce and they should have a minimum production requirement. Apart from that, they are also free to sell 25% in the market.
Captive users are there who are violating.
That
If you are coming in PIL, then why you cannot chase one? You have to come with a broader aspect and then say that the state should formulate this, the state should follow this. Where is your?
My lord, I have relied on the CAG report. I have indicated those part of the CAG report which says that what was the requirement and what is the objective that the auction. Please have not.
Mm.
33H. Now, kindly see 133H for that matter, please.
Yes.
My lord, may kindly come to the prayer at 132, my lord. E. Issue an appropriate writ order direction to respond number 1 to 4 to file a detailed affidavit placing.
PIL lies to direct a particular party to file its pleading. If he chose not to file the pleading, the court will decide it ex parte against him. In a PIL lie, I'm a learner. I'm a very good student. Don't worry. I have still a lot of inclination to learn every day.
My lord, please be proud on.
Tell me whether it lies. It is open to the litigant whether to file his pleading or not to file his pleading. If he does not, doctrinal non-travelers will come into play. If he does, the court will decide on the basis. Can a PIL lie to enforce the filing of the pleading? I do not know. Let me learn.
No, to that extent, it is my PIL is not to extract a response from the state government.
I have not seen. You have referred to E for that. I just said. Can a court enforce a party to file a pleading?
Steps to be taken on the CAG report compliance.
If he does not,
no private party will come before a high court. No private party will come before a high court to with a prayer that please direct the state government what kind of compliances they have done in terms of the CAG report. Well, that's common cause.
Again, I'm telling you, that's a different aspect. If there is any violation of the statutory provisions, if there is anything which the state has not done, which he is mandated to do under the statute, I can understand a writ in the nature of a mandamus can be passed, or if they have taken a decision, the writ in the nature of a certiorari can also be issued. But so far as the pleading part is concerned, can a PIL file that you file your pleading in that case? I mandate you to file.
No, that's not my prayer.
That is what the E.
No, E is CAG report compliance.
No, sir.
Well, the other writ petition has nothing to do with CAG.
The respondent number 1 to 4 to file a detailed affidavit placing on record the step taken, if any, for the implementation of the recommendation and to punish, where they will file the affidavit.
Well, before this, Honorable High Court.
That prayer is made. First time I come to know.
No, CAG, Lord Supreme Court and Arun Agarwal has clearly held that CAG is not something which can be judicially taken a note of. It can't be. CAG is for the parliament, not in the.
So also paper cutting, my lord. So bar and bench is no standard to malign where the court does not speak about it. They are relying on random newspaper articles and they are maligning my image.
Sir, I have not come across with these kind of pleadings. Maybe that's my shortcoming.
No, my lord, absolutely.
That in a writ petition, prayer is made to direct them to file an affidavit.
No,
I have not come across.
May I make a submission?
Neither there for nearly 19 years, nor here for nearly 15 years.
My lord, please. My lord, my submissions are very, very simple, man. When there is a minimum production requirement, and that becomes a big criteria.
I understand everything, but again I'm saying that for that minimum requirement, if they do not meet, the state has already taken a step by issuance of the show cause notice, imposing a penalty upon them. Then in that event, how the PIL would lie? Is it not a parallel litigations to done away with whatever has been decided or any interim order passed in another writ petition which is pending before the High Court?
With all due respect, my lord, I beg to differ.
If we say that you proceed, just say, as you said, yes, you have violated the terms and conditions, you have to pay the penalties. What would happen to the other writ petition where they are already may I use the word, the blessed with the interim order?
My lord,
what will happen?
My lord,
it is procured.
My lord, the scope and ambit of this one, that these minimum requirement that they are not fulfilled.
Are you not understanding what is playing in our mind? Sir, you are in PIL, kind of visualize the situation.
I understand.
Then
I am a limited job.
Then
I have my.
You are not coming as an aggrieved person in that sense that you are benefited by this. You are coming with the larger issues. And where there are several litigations which are touching upon those issues are pending before the court.
That is exactly my point.
That is what
That
I'm
is
saying.
exactly my point.
But then PIL lies. I'm asking you.
My lord, that is exactly my point.
My point.
My lord, these private parties will not raise these issues. My lord, the state government has
The
nowhere
matter
said.
is already traveling in the docket of the court. The matter is there. Whether the penalty which they have imposed is sustainable in law, the court will decide. Whenever the matter would come, what we will do in the PIL.
But I am not on the penalty. I am on the very grant.
Sir, grant on the basis of what?
On the basis of the fact that they have
12A.
My lord, not 12A. Production requirement.
Whatever. If,
My lord,
sir,
under
the
MDP.
statute provides that if you do not meet the requisite production, then there are consequences which are provided in the statute. One of the consequences is imposition of the penalty which they imposed.
My lord, the bid criteria.
Have they not imposed?
My lord, the very bid criteria, if it is incorrect.
Then again, you are going back. What you were doing since 2021.
Well, I have. My lord,
2025.
I did not.
CAG report sees the light of the day in 2024.
My lord,
what you were doing from 2020 to 2024?
My lord, as a public interest litigant, may I make my submission, my lord? As a public interest litigation, I'm quite conscious of that. And with that consciousness, my lord, please, I stand to that consciousness, my lord. I am not shying away from anyone. That's what I said. Let me respond to each and every allegation they have made. I will meet with these allegations. My lord, the state's response. My lord, why I say
other matters which was directed to be listed have not been listed.
Yes, sir. That was the
those are 43, item 43.
Those were 43, Lord. Before that, which are Lordship where Dr. Sikhi etc. Those were the other matters.
This matter was also tagged with those matters.
No. You made a statement that same issues are arising, Your Lordship, on the ex-party statement of the senior counsel appearing for it. Has listed it on with that.
No, my lord, let it be detagged. I don't have a difficulty.
Not question of detagged. Not detagged.
No, my lord, may I make one submission, my lord? The criteria which is required, which was the summum bonum on the basis of which the entire auction was made. When that particular criteria is not met out, it goes to the root.
Episode of 2019. I have read this brief just now. It was the episode of 2019. What you were doing. That's I say the mutually destructive arguments. One, you say that in 2019, the criteria, the conditions which was imposed in the NIT has not been followed. They cannot do it. They were not eligible. They cannot do it. One. Secondly, you say that there was a minimum productions which is required under this substantive statute. They are not meeting that requirement. They are not producing those. They are producing less. Even they have gone to the government and then reduced that particular production. These are all mutually destructive arguments.
My lord, if the state has slept over the entire issue.
They have not slept over. They immediately took steps, show cause notice, imposed penalty on them.
No, my lord, then please 706.
Ultimately, if their writ petition fails, interim order is vacated, they will definitely realize the money from them.
3,000 crores, my lord, the amount of penalty they have imposed, when they will recover is already 6 years, and the state government did not have an opportunity to even file a response. And if this cannot be brought before your lordships by a PIL, then what else, my lord? My lord, no party will come.
I am in fix. Again, I am saying that can a PIL lies in this?
This is exactly a point, my lord, in my humble submission.
One law,
my lord, in my humble submission.
Decision that if there is no pleading filed in the earlier litigations or other litigations, the PI will come mandating the state to immediately wake up, file your pleadings, contest.
My lord, please 706. Please. No. Please, my lord, 706. Please come to page P27 706.
Nothing.
Sir, please come. I have my bona fide.
I gave you an adequate and ample opportunity of arguing, but I think the main issue you are really digressing there from. You are not responding to the main issue. You should restrict to your prayers and you should show that the PIL of this nature.
Then my lord 706 I will show for a moment, then I'll take your lordship to the MDPA. Where lies the illegality, my lord, which goes to the root.
We are not going to decide this illegality or the legality. We will simply say, first thing is, though I know that so far as the locus part is concerned, the locus standi in a PIL is somehow diluted, should not be so much taken into account. But still your bona fide.
Yes, my lord.
If you are a busybody, if you are a busybody
I'm not. I am not signing away. From those questions, I am not signing away, my lord. One of the most, my lord, the glaring jurisprudential turn has been given by Energy Watchdog. My learned senior is also aware. He also keeps referring. So no,
I was impressed. That's why the first question which I asked against him, that why you are against this particular watchdog.
Justice Rohington Nariman's judgment of Energy Watchdog, we are referring to each and every day, my lord.
That's why we appreciate this particular ethics, the word watchdog.
My lord, please come to. My lord, please bear with me. My lord has given a hearing to be 706. My lord, pays.
Now there are a lot of councils who are waiting.
No, my lord, in that case, my lord.
No, not in that.
My lord, please come to page 706, my lord. P27. My lord, this is the substantive writ petition filed by them, my lord. My lord, kindly see, look at the order date 24/06/2021. For reasons stated in the application, so and so writ petition civil number 1670. May I read? Paragraph 3. Yes. On hearing the submission of Mr. Salve, senior counsel for the petitioners, the issue that arises for consideration is whether the opposite parties are justified in refusing to permit the petition number 1, which is the specified end user, as per the MDPA agreement dated so and so, to captively utilize the iron ore from Roida to ore mine.
Subsidiary.
Yes.
Subsidiary company.
As Mr. Salve has pointed out that the relevant details to show the relationship of the holding and the subsidiary, the petitioner and ADPL have already been made available to the opposite party by the petitioner's letter dated so and so. Further states that the copies of the latest annual report of the petitioner showing the exact shareholding pattern, which would clarify the schematic chart enclosed with the aforementioned letter, will be provided to the Learned Advocate General today itself. Then my lord may kindly come to paragraph number 6. Mr. Ashok Parija, Learned AG, seeks a short adjournment to revert on the issue whether the document placed before the opposite parties demonstrate the relationship between the petitioner and ASPL.
As a holding and the subsidiary.
Yes, my lord. Till then, no coercive action. My lord, therefore,
this is what they say, that this may be a mine which is given to me for this specified end user or captive, the user. Now my subsidiary, I wanted to utilize, my subsidiary should also utilize. Now the question was whether this particular company is a subsidiary of the holding company. You know the concept. Old one, I think section 4 of the Companies Act. 51%. It says that what is the holding company and what is the subsidiary company. There's a defined one. It's a defined. So it's again the matter of investigation.
But my lord, they have on page number 825, they have further sought time and they have not filed any response, which I made part of my letter.
With the folded hand, I am asking repeatedly, can a PIL lie to enforce this? You are, I think 100 times you have said that the state has not filed a response, has not filed affidavit. Does it lie on that scope?
Then my lord, then
I have not come across. Show us. I am still, my mind is open, sir.
My lord, then
show us the law. I am ready to change my mind. Nobody should remain ignorant throughout his life. They should always be a good student, as I said.
Wanting to
learn. Let me learn.
My lord, I'm grateful to the lordships and my senior. My lord, 548 is the page where the minimum production requirement is dealt under the MDPA. After the leasehold rights, now the MDPA is executed between the successful bidder and the statement. Now, please come to 548. What is the minimum production requirement? Where I'm concerned, please 548.
Correct. They have not. Let us proceed on that premise that they have not complied that minimum production the obligation. Let us proceed. Let us stick it. For this violation, there is the consequences provided in the statute itself. What are the consequences? That if you do not meet the minimum production, then the state can impose or show cause notice, impose penalty on them, so that the state may not lose its exchequer. They have imposed penalty. What more you expect from the state to do?
Why not a day
Go immediately close down the entire mines, to do it, to remove everybody, to capture it, and then
a day
now I restrain myself because
the day before, the state stated the day before that you cannot do that. You cannot go back on that. On the teeth of that, they have executed, stating that I will be complying with that. My issue is not penalty. They cannot buy their inability to produce. It goes to the root and the leasehold right is to be cancelled.
You know that they do not have the capacity.
They themselves check it. That's their whole case.
Are you a shareholder? Are you the managing director or at the board of directors? If they have said that they will not do it and the reduction they have sought for, the state will take action against them.
State is not taking action.
They have taken action against them.
Since it's argued so much, let me just clarify only one point. The shortfall in production was only in the first year, which was that COVID year. And we actually demonstrated to the High Court that our subsidiary company was delayed in blood accepting for the purposes of blood consumption. That is why your lordship granted me an interim order. And second year onwards, blood production is all absent. So I don't know what my friend is wanting to argue. I mean, this can't be, he can't just go on and on like this.
My lord, the MDPA requirement will go to the root, my lord. That's my whole case.
Let the state say whatever.
My lord, let the state file a reply. Let the PI be pending. My lord, I am not running away. My lord, I will let the state file a reply, my lord. The state on the very first day they appeared.
This can't be a fancy litigations that you just compel the state to do something.
My lord, it was
which is within their prerogative, whether to file pleading or not to file pleading. It is within the wisdom of the state to do it.
My lord,
if they do not, we proceed on the basis of a statement.
My lord, it is your
What is your stand?
Ex-party order.
Past 45 minutes, my friend is castigating state has not responded. And which are those matters? Those matters are listed today at serial number 43. Where in almost 4 cases we have already filed counter affidavit, and 1 or 2 matters your lordship few minutes back have granted us the opportunity to file the counter affidavit within 2 weeks. And in all the cases, the virus of the statute, the central legislation is under challenge. The interim orders are operating. What more the state can do? State has issued the demand notice.
The state, I mean, he wanted the state to stand by his side and whatever it dictates. Good.
My lord, the virus was challenged in 25. What the state was doing from 21 to 25, my lord,
that is
my lord, my virus got challenged this year.
That question should be put to you from 2021. Why you are sitting silent till 2025?
You have imposed those penalties.
Yes, 1,300 crores.
That subject matter. And
my lord, they never responded to my. It doesn't lie, my lord. They don't respond to my representation.
And for the last,
my lord, none of the representatives. And your lordship's last order, they are not complying. If they are saying in the connected matters reply has been filed, they were very much present. The last occasion they did not buzz. 2021 matter on the purely on this question, man. I mean, I can understand. What stopped them from complying with your lordship's final last order of 9 September? Nothing stopped them from doing that.
Order on misrepresentation.
There was no misrepresentation at all, my lord. Everything is black and white and clear, your lordships. And second thing, the state was present here.
You have filed your affidavit?
I have filed my affidavit only on preliminary objection. Only. And the one thing which I have not taken, which I should have taken, not which I have argued, is that this is a contempt because you are saying that orders are procured and orders, High Court is continuing with these orders, and that is why not this PIL is maintainable. That's the whole. Because this interim order is not something which continues on its own. Your lordships every time have granted the interim order till the next day. And when it has been justified further, it has been extended further. Even this bench today also not has continued the interim order. And for him to say that we have procured these interim orders and accordingly this PIL should lie because of that.
No, that is not the basis of lying this PIL. I never said.
Even a prayer is made for that. Prayer R is made.
I have seen. There are many prayers which he has made. He has to.
And the first prayer is 12A. The very first prayer is 12A, which came later.
That's I find that everything was finalized prior to that. That's all. I think nothing. No, my lord, please come to the MDPA. My lord, let me show the MDPA. Everything we have seen. No, my lord, let the plenary objections. No, because the state is the understand. No, the stand they have not complied. PIL we have to consider. No, my lord, if the state is taking a stand without filing a response in compliance of your lordship's last order, even if for a matter heard that in those matters he has already filed the affidavits. My lord, he has filed. He has said in front of you that I have filed. I didn't have any idea that this is really connected with the 43. I just thought that's independent public interest litigation, and then even if 12A is found to be intra-virus, yet whether you can take advantage of 12A. So that's why we segregated it. I will not go to the amendment at all. I'm on production, my lord. I'm not on dispatch. That's the whole case. And what are the consequences? My lord, very precisely, the state government has chosen not to file a reply. That's all. We'll consider whether this kind of a PIL lies. Let us see what decide. Very important. Decide. Where is the provision for imposition of the penalty if there is any shortfall from the substantive provisions? Forget about the rules. The Parent Act, which talks about the production and not the dispatch. Yes.
The controversy there is in the other expectation. Although I'm not agreeing that. There it is
more backing upon that. I just wanted, which is the provision relating to
12A1.
No, that is a rule.
No, that demand is there.
No,
Not in the Act.
I just wanted the Parent Act because there is a variance.
This is only the rule, not in the Act.
No, that means the rules contemplates the dispatch. But the Parent Act contemplates the production. I just wanted that particular provision of
yes. That is the virus, your lordship.
You just showed me that provision, which section?
4 capital V block.
Yes.
Notwithstanding anything contained in section 4A, the central government may, in the interest of maintaining sustained production of minerals in the country, prescribe such conditions as will be necessary for commencement and continuation of production by the holders of mining leases who have acquired rights approval. So it's only clear.
Is there any consequences provided for a condition of
No, not in the end.
It is not. And
the consequences are provided
in the rules.
Yes, 13.2 block double is the rule making part. 13.2 double is. And these penalties are all coming under the rules. If your lordship will see 13 subsection 2.
I have said
double A.
These conditions have been necessary for commencement and continuation.
Also talking of production. And here they are talking of dispatch, and that is why the virus.
I just wanted the consequences if there is any violation.
And the violation is because of the non-dispatch, this penalty has been imposed.
Then because not production, if there is any provision for
no, not in the
Act. Consequences in the Act.
Not in the Act, it's only in the rules.
That is what I really wanted.
Yes, sir.
And that is in the rules.
That is in the rules.
Suppose if we forget Rule 12A, was there any other rule?
No. Prior to this, there was no. In the rules, when I started the mine, when the agreement was, when I was declared LOI, there was no requirement. If your lordship will see 12 capital A of the rules, which is inserted on 20th of March 2020, after the bid process was over and as was declared as L1, this rule has come. But only not as an officer of the court, I would only beseech your lordships to, because this is all substantively there in the other petitions. If your lordship makes some comment, it may go one way or the other. So I don't want your lordship to get stated because this petition, on the face of it, if he is saying that my award is not correct because of 12A came later. If he is saying that I have procured orders from the court, that Lord is scandalous, contemptuous, and that is to be dismissed with Lord cost. Because his whole petition.
Section 4 provides for premature termination. So there is.
Yes, that also is there. So that is why your lordships, no coercive steps not protects us.
Well, 4A talks about time.
There is no issue lot of 4A here because 4A will
No,
come.
that's the eventuality which are given is not really.
Yes.
I understand. But there is a provision for premature termination.
None of these issues arise in this case at all. It is mostly related to safety, etc.
Yes, sir.
Well, just that for 548, please, I'm placing that. Please look at 548 for a moment.
That's enough.
I'm just placing it. May I look at it?
Just note it, 548.
548 read with my lord 528. 529. That is my case. The production requirement. I'm not on dispatch one.
This is also after the bid process.
The production will definitely come after the lease is granted.
Firstly, and secondly, I met the production, I have not met the dispatch, which is coming later. Dispatch was not there when the award was there.
Consider it. That's why I say there appears to be a mutually destructive. Like one go you say you are not eligible, and second go say no production. I do not know.
Well, hence I said 529. On the teeth of 529, 548 came. That's my.
It's called the mix.
DP of the
Item number 10.
May I please? It's an DC under the OMMC rules, Lordship. And its agreement is valid up to 2027, Lordship. 5 years agreement, Lordship. It is valid up to 2027, Lordship. Because the agreement, Lordship, on the March 2022, Lordship is valid up to 2027. Then in between, Lordship, I was operating by virtue of the Lordship appropriate orders. And Lordship, kindly the Kazakhstan RO, Lordship, kindly come to page 56 and Annexure 3.
What it says.
Lordship, this is Lordship.
Show cause notice.
Lordship, by virtue of a show cause notice, Lordship, they have seized my excavators, Lordship, and subsequent consequential, they have stopped my mining.
You are stacking the
Lordship, kindly see the
area.
Lordship, kindly see the allegations, Lordship. Kindly, kind permission, Lordship, may I read that? Show cause notice, Lordship.
You have also doing a mining activities beyond the lease area.
Lordship, that is the allegations, Lordship. Please see, Lordship, what is the reason that is the show cause itself?
Go and give an answer.
No, already answered, Lordship. Already answered. Lordship, I have filed the reply.
Has been given.
Yes, Lordship.
Then have they taken any decision?
No, Lordship. What
are you doing, sir?
No, what they did, Lordship, that is more, Lordship, shocking, Lordship. Lordship, after 2 months, Lordship, though the statute never permits them to file an FIR, they filed an FIR and illegally they have seized my vehicles since last, Lordship, 35/25, which is never permissible as per Rule 51 of the rules, Lordship. Lordship, kindly permit to place, Lordship, what they have done. To what extent that traveling, Lordship, kindly.
I got your point. You are saying that this is what the situation. Show cause notice was issued. You have given a reply without giving an opportunity, without passing any order. They have proceeded and did something which is beyond the powers.
Lordship, it is contrary to Rule 51. Lordship, it cannot be seized by a squad.
It has been seized by a squad when the rules never prescribes up to squad to seize my vehicle, Lordship.
Okay.
Lordship, Rule 51, Lordship.
What means?
Squad, they used the word squad, Lordship. Yes, this squad. There is squad, Lordship. It has to be. If at all it is held by someone, Lordship, authorized person, then I don't have any case, Lordship.
You don't have any case.
Lordship, kindly come to Rule 51 for a moment.
That is done by the court or what?
No, 51, let's say 51, penalties, let's say penalties under what circumstance, they can go for Rule 50 penalties. Let's say starts from
Courts can only.
Let's see.
Court can only.
No, let's see, 2. Roman 2, let's see. The director or additional director or joint director or deputy director of mines officer or assistant mining officer or junior mining officer or divisional forest officer or assistant conservator of forest or range officer or police officer not below the rank of sub-inspector of police may seize the minor minerals and its products together with all tools, equipment and vehicles used in committing such offense within their respective jurisdiction. So, Lordship, kindly see the allegations. They are not saying I am not doing any illegalities. On presumption, Lordship, kindly see the wording not that as 56 on show cause notice. Lordship, kindly with Lordship, page 56 I am reading, Lordship. With reference to subject cited above, I am to say that during the field visit of GV Nagar area in and around village Kuntapal by mining squad on 30 and 25, symptoms of mechanized mining were detected outside the lease area of Dighi 1 and 2, and you also constructed a road across the river from the opposite side of the source of the obstructed natural flow of river. Further, squad has seized 2 numbers of excavators. Detect approximately 30 cubic meter of sand stacking illegally outside the lease area, which violates the terms of
I got your point. What do you have to say? What instruction? How can it be? It can only be done by a director or additional director or joint director or deputy director or mining officer or assistant mining or a junior mining or a divisional. These are the for a police officer not below the rank of sub-inspector. They seize the minor wells.
Well, we have delivered one order.
I have quoted the judgment, Lordship. That is my
judgment respect to the Tahsildar. The Tahsildar not being the authority.
No, the sentencing part, which we say that it can only be done by the court, not other persons. What they were doing is that they were imposing a fine.
Penalty, yes.
Fine, not penalty.
There is no word about penalty. Mr. Proctor, I think.
Yes, Proctor
was
there.
It was imposing fine of 5
The
lakhs.
Lordship has interpreted 15.1 and 15.4. Pass that on. Both.
We have compared to provisions.
Here it is a matter with respect to seizure of the vehicle.
I am asking you, I understand. The seizure of the vehicle that can be done by these officers who are named there.
Yes.
Now it appears that you talk about a mining squad. Now mining squad comprises of which officers? Director, additional director, mining officer, or junior mining officer,
Mining
or a
officer.
divisional forest officer, or assistant conservator. What?
Mining officer. Oh, your Lordship may kindly see page
He has
59.
not said. He simply is communicating that my squad, mining squad has. He was not there. He did not say so.
Squad has seized. That is
Now, what are the members of the squad?
regarding that, I'll have to bring instruction. Because page 69, the mining officer.
Every authority, this is mentioned in precisely 2, clause 2 of rule 1. That is conjoined by all.
Yes.
Not in the.
No, not one judge. Any one of them. Any one of
Sir,
them. All.
conjoined by all.
All. Yes.
Each one is an individual officer.
Yes. Yes.
Not a squad.
Not a squad. Individual officer.
It is not a team of officers.
And Roman 3 also very shocking, Lordship. No court shall take cognizance of any punishable.
That is what I am saying.
Lordship.
We have delivered what.
Lordship, Lordship. I was there, Lordship.
Mr.
Lordship.
Senior advocate. You are conducting.
Lordship watched on the very day, Lordship, here, Lordship, they made us fine. And Lordship, after 2 months, they are filing an FIR.
That we are not concerned with the FIR.
No, Lordship,
We are not going into this.
Lordship.
We are more concerned with the seizure which they have.
Lordship.
And squashing of the FIR.
No, I'm not saying, Lordship. 2 months they returned my vehicle. And Lordship, with a different story, this same mining officer is doing this further act, is making penalty, Lordship. Then Lordship coming with this paper. After 2 months, without going to the court, Lordship. When 3 speaks.
So it has been addressed. It's called the next.
Item 18.
May I please, as per the lordship's order, that in paragraph 5, it has been stated that we grant time to the department to collate and collect the documents as a requisition by the petitioners. Simultaneously, we find that if a proceeding under section 140 of the Act is allowed to be proceeded with and reach the final destination, it would cause a greater injustice to the petitioner assessee, and therefore we restrain the assessing officer from proceeding further taking further decision on the basis of the notice dated 30th June 2020. My lord, as we have asked for documents as per Annexure 2, stating at page 27.
Yes.
Copy of evidences collected during the search proceeding and post-search investigation, which reveals that the finance brokers were engaged in unaccounted cash transaction on a larger scale.
Yes, I already received the instruction and require document manner. I will file online manner. Would that be?
Give it to him. The matter ends here and now.
Madam.
Have you collated and collected all the documents which you have relied upon?
Madam.
Where?
Yeah.
Give it to him by a covering letter.
Madam.
That is what we see.
Related.
Whatever they have relied upon, your contention was that in 148A, they proceeded without relying on a document which they never supplied to me. You wanted those documents. Now we are giving those documents, no difficulty, and we will pass the appropriate order so that they can proceed from that stage. But we will not pause the whole.
I don't, my lord, I asked only for documents and basing on document whether 148 proceeding will be started or not. Then
It has started.
Because
It has started
if that
and it
document,
will
if my name
continue
is not
after
there,
this production.
if the documents, my name is not there.
You can give.
Tomorrow.
Should we fix this matter on Monday? Fix this matter on Monday for this one.
Right. Item 19.
Yes.
What is there?
Yes, in the next thing. If there be any.
19.
I agree, Your Lord. Why your IPC is blocked?
Sir, violation of the violation of the principles of natural, they are blocked.
Why? What? Violation principles of natural justice.
So without giving any notice to me, thereafter, on getting it, you have inquired about it. Thereafter, it is that he is now not functioning. But the time I had confirmed it, he was a registered dealer. And now, if he is not functioning, that cannot be a ground for me that it will be blocked for that. So I have given after inquiring the representation showing that my totally bona fide of packages, the total annexed by giving that, and still they are not passing any order on that. They have never issued me that any notice of post or plea. We have learned that actually
Why you have not issued any notice? Why you have not served any?
Your Lordship, as per rule 86, your Lordship has also decided no notice is required prior to the blocking. Your Lordship, it is the interim arrangement, your Lordship, so the blocking is fine. Your Lordship has also decided the reason of blocking, your Lordship, has been communicated, and your Lordship may kindly look into the second page. The first page is the alert notice was, and the second page is the VGI investigation, how the transactions have been made, your Lordship. Under what circumstances the transactions have been made, and what is the status of the supplier, your Lordship. The first number one is the supplier. Your Lordship may kindly turn to paragraph 3, 4, 5, your Lordship. This is internal notice in communication, so I may not in loud voice, your Lordship may kindly go through. 3, 4, 5.
So 9. Oh, sorry, annexure 2. Annexure 2 is forming part of annexure 1. Because annexure 1 reveals, please view your credit ledger on the portal for details. Annexure 2, I believe it is
the reason, the blocking and reason. Reason is supplier non-function.
Non-functioning from each date at the time of transaction or thereafter or prior to the
transactions are your Lordship. Your Lordship, I can understand your Lordship.
Why reason is one has to understand. So what would you understand from this?
From this, the
This is blocked. Why it is blocked? Because supplier is found non-functioning.
Non-function. Your Lordship.
Since when?
Your Lordship, may kindly go through that.
So
your Lordship.
this is your document, but how can we know?
Your Lordship, it is an interim investigation, your Lordship.
So the returns have been filed. That is being shown in the portal. The 2A and everything is there.
This is
And
not
what?
So your client has not given you the full information.
And your Lordship has also decided.
Whatever this is my inspection and the documents say.
Your instruction is inchoate instructions, not full.
So they have never disclosed me that any, neither given the what are the reasons they are doing it. That must be because that independent application of mind for reasons to believe to block will be there. That is my Lord's judgment. And they have to dispose of.
There is incriminating materials which have been disclosed, which they found. It is under investigation, which is continuing, and the facts which they found. And your client knows everything. Your client has not given you a proper instruction.
That the seller.
Your client knows everything.
That the seller has sold me. I have mentioned in the returns. I have shown in. He has paid the taxes.
You are hinting at para 5
Your Lordship.
of
the page 3.
So it is not relatable to this particular. It is supplier.
Supplier has passed on. So illegal passed on.
What I say. We are under impression that these persons are relatable to purchaser.
No,
So I have asked him that your client
No,
has not given you the full.
suppliers have passed on the bogus ITC to this party.
This order after notice which you are referring to is not a party date.
No, he is a party. So the transaction in between the supplier and who is it?
Yes, sir. We are able to understand.
Answer. Answer.
Whatever you are, we are there. We are under impression that purchaser was investigated and his persons have admitted.
No, suppliers have. Answer. Answer. Answer.
That is why hinting at this annexer 2, I am asking you, what is the reason? From which date they are
the particular transaction, the particular ITC which has been blocked, which has been carried forward from this particular, this supplier have been blocked.
So from the very
What is your
beginning,
so what is his involvement?
Your Lordship, this is the paper transaction. This is the paper transaction in between the supplier and the purchaser. And that paper transaction has been, the investigation is going on.
Where is the adjudication? Then before adjudication or penalization?
Your Lordship, 86 says before adjudication. Rule
before
86
adjudication,
says
but that-
is the before adjudication. It is an interim protection of the revenue as per Rule 86A. Rule 86A says the blocking is only for a period of 1 year. If the entire investigation and adjudication will not be completed within 1 year, then it will be automatically unblocked. So within 1 year, the investigation has to be completed, and pursuant to that investigation, the adjudication proceeding under section 73 or 74 has to be completed within that 1 year. So now it is under investigation. The investigation is continuing. So after
When you have unblocked, when you have blocked,
well, not in the month of May,
Mr.
May
Mr. Tell me one thing. If investigation is continuing, right, with respect to supply,
no, both.
Then how can you conclude 73? 73 is not investigation, it is adjudication.
No, I'm sorry, I could not understand.
After Mr. You said the investigation is continuing.
Everything will be completed within 1 year. I'm sorry, I have to make sure.
no.
That must stop it. Because after these circumstances, your Lordship has already decided in one case, a first judgment, your Lordship, so far the transcript. In that case, one step ahead, what my Lord has asked. In that case, the same, everything same. Only there we have concluded the investigation and so good notice have been issued under section 7. Only that is the difference in that. Here, the procedure investigation has not been completed, notice has not been issued. This paragraph 6, page 11. Page 11, paragraph 6. The last 4 lines your Lordship may kindly try to. Here the facts are same, only DRC 01A has been issued. Shall I place it? As it's transparent, blocking the ITC, the same everything same.
That is under consideration. Has he filed his reply?
Yes, sir, I filed my reply in another file. No so-called voluntary, I have filed it. Even given the total details of the purchases, total detail of each, this thing, everything I have filed it, but they have not passed any order. Unaccept.
You are not, are you blocking entire,
No,
or this transaction only? Sir, that's a tax implication. Tax implication related to this transaction. You have problem.
Only this transaction, 46 lakhs, the transaction, and he has also admitted that is against the supplier. 88, that this is particularly the same supplier, only one supplier.
If we suppose, sir, here that they have cancelled it to retrospective.
What?
The license, which I have updated to me that they have cancelled it in the retrospective. And that is from the entire for the total.
It's still at the very nascent stage. They have simply blocked because you will not be permitted to take advantage of this.
Okay, that is not a COVID.
This is another investigation.
No, it is.
Now,
I am giving
permissible, which is permissible under
Rule 86 capital.
86 A capital A. What more? Only thing is we can simply tell them to expedite it.
But they have to pass an order that against that.
What is the order to be passed? Investigation is going on.
If
they want
on
to
my
proceed against you under section 73 or 74, they will give you a notice.
But when I have to file that, it has been stated by the court that you have to file against your petition. I have given that in an annex of annex of 5 series. That's the total what is purchasing.
Has been fraudulently added for its ineligible.
So where is the fraudulent? And he has filed the returns. Your tax has been paid by him, and I have complied with the section 15, and total details have been given the representation to unblock it.
No,
The order has to pass from that when we file
that. Your supplier submitted the return.
Yes,
his certificate has not been suspended as yet.
They have now suspended it and
that has been suspended. I'm just asked whether the registration number has been suspended or blocked. No, your supplier.
That supplier, sir, actually I am a purchaser. When I have purchased it, is here registered. So now if he is not continuing it, the titles which I have brought the emails, the bills, all the requirements of conditions of this act you have completed, the payments have been made, the total details I have already submitted to the officer concerned. He has not to pass it and and to withdraw that, unblock the theory, but nothing has happened. So we, at the time, we had said that natural justice has to be given, that the order has to be passed. My lords have already given that the regions must be there that has been held in that order.
But there is nothing which has been blocking does not require any reason to be given. If there is a reason to believe.
That reason to believe, I have not received any copy from that.
This reason to believe is
more subjective for blocking my
subjective. Then if they want to say that they will unblock it, there is no difficulty.
Sir, then the section is there. It is a doctrinal law in that way. We, sir, previously actually had it. We are GSTR coming that even in a blocking that you have the reasons of money has to be given and the hearing has to be given. In that case, we have my lords have directed them to pass that order and that representatives which have been given in 5 years. Yes. He has never passed it.
Yes.
And natural justice, I write it because it is there from the very beginning that he has to be read within when it is not.
Complete the investigation.
Sir, that investigation for the seller, sir, how I am liable, sir.
Paragraph 5 and 6 of the allotment.
Sir, if the seller has paid the tax, it is in the return, I have annexed with it. And the return to has been filed, and everything has been given, sir. Neither they are passing any order nor any giving. I am a purchaser, how the seller has to be, if you proceed with the seller, you proceed with him.
Yes.
Item 20. Mr. Math.
Regarding the non-constitutional case.
No, that's not.
No, now.
Notification has come.
Yes, notification has come, but the registration and the website has not completely started, so it's not working full steadily. So that is why I like it.
Yes.
Madam. Item 21.
It's a challenging to cancellation of registration. Yes.
Item 22.
Same.
Item 23.
Item 20. Firstly, I can see, in the vacation you will see. This case I may be permitted to make an inquiry because it is place of business. Your Lordship, an earlier case also granted no time. But for the first time, I will make an inquiry and submit inquiry.
Yes.
Not as property.
Cancellation.
Cancellation of parcel. Claim once from time. Money.
Yes.
2 weeks.
Yes.
Item 24.
Here the interest for property is directly against these. All of us single judge the Ramester 1. No region has been assigned. The background of the case is that initially there was an award passed by the permanent local. Specific order, and there was no state.
How can you support this order? No reason. Simply going by the exit of the fact finding authorities decision. We have highlighted there are so many judgments of the Supreme Court. It talks about the reasons to be provided. What is this order?
And that too, the fact finding committee had no occasion also, there is no authority because there was an award.
Go serve a notice. I think you can represent 1, 2, 3, 4. 5 notice to go. You waive notice. 5 notices.
Because I don't know where to get for the state.
Different panel.
State is they can
State pollution control.
It's a pollution control board. Is there one advocate who is serious or there is a panel?
Earlier there was panel. Presently, I am being told that the pollution board also the state is accepting it. Something better. We should notice to OP number 5.
Waive notice is waived so far as
Fine, says speed post. Speed postman. By within 3 months.
3 was.
Item 25. Sixth.
The respondent challenged the correctness of the answer key published by OPSC in respect of 2 questions. The learned single judge has accepted the contention of the respondent in respect of 1 question. The judgment starts at page 10, and if your lordships may see the question at page 12.
Which order you are referring?
Well, this is the order dated 24 December 24 at Annexure 1.
Yes.
At page 12, Roman 7, the question is there.
No. Organon.
Yes, sir. The first edition of Organon was published when Dr. Hahnemann was at. The petitioner contends the answer should be A. Torgau. The OPSC experts have given the answer as B. Leipzig.
They are more intelligent than you.
The learned single judge on the basis, the reasoning is at page 24.
No, 8. What does this 8 signify?
But the single judge accepts the contention of the respondent.
8. Italic.
Yes, ma'am. The correct answer was listed as A until 7th December 23.
Until that time.
Yes, ma'am. However, the answer was changed to B by the opposite party number 3. Whereas what has happened is, when the question first came out, I published an answer key and OPSC also gave the answer as A. Then I will show you, Lordships, that we received several objections. As per our policy, we invited objections from candidates. Several candidates objected and said that the answer should be B, and this is the publication which says that the answer should be B. And the OPSC experts accepted that contention that the answer should be B. It is then that the respondents came to this court and said that the answer should be A and should not be B.
So what you have done?
Well, we have
you awarded the marks both to A and B?
We have awarded the marks only in respect of B. By way of this judgment, the court has directed that the marks be also be granted for A in respect of the petitioners. And the reasoning, if your lordship sees at page 24,
is a more rational way of looking at it. Your answer B says A.
But my experts, on the basis of the literature that they have seen, have given the answer as B.
That's the only point.
Yes, sir. And if your lordship sees the reasoning of the learned single judge at page 24, the learned single judge has relied on two issues, my lord. Paragraph 25. With respect to your lordship as paragraph 25. The main contention was that in 2016, this same question was there and the answer was Torgau.
By the same OPSC.
But I will show you, lordships, that question, the 2016 question is at page 25. Page 25 top.
Yes.
The first edition of Organon of Medicine was published from. If your lordship compares page 25 to page 12, there is a subtle difference. The questions are not the same.
Published from.
Published from. And 2024 question was published when Dr. Hahnemann was at. So there is a very subtle difference between the two questions.
True.
Therefore, Malas, the first, on this point, Malas, it could not have been granted. The second contention is at page 20, is in paragraph 28. Some books have stated that A. Torgau should be the answer. But then, Malas, the Honorable Supreme Court has clearly stated that in case of a conflict between literature, then it is the opinion of the experts which has to be accepted.
May I please see Supreme Court decision or the same decision?
I just
Yes, sir. I am carrying some Supreme Court judgments.
The same Supreme Court decision clearly says that if any inferential process is not involved, if it is data only, then things stand separately.
There is a difference when it relates to any kind of a the factual or the historical things. Then in that way, the Supreme Court has said that the body of experts is constituted. That would be the correct one.
Well,
So in that event, the Supreme Court has said that the court should not substitute it himself, nor should take care of this.
But I have,
So here there is a distinction between the two portions which he has relied upon 2016 and 2025. Because the language is very, I would say, they wanted to confuse the candidate.
it is a question.
One is published at a particular place which may be distant from the residence of the author, and it was at the time of publication, where was the residence of the author? These are the two different things.
My lord, all the books, except I don't know what he relied upon, but I have relied upon 9 books. All the books uniformly say that it was published in Pudagaon. Even one book I have brought right now, I can place you.
No, published may be there.
No, published. He was also there and the publication was also.
That is what is, whether he was there at the time of publication.
That is also written there now. He was there in Pudagaon and here the book was published in Pudagaon.
Next one is the homeopathy.
Yes, ma'am. Homeopathy.
And I can give you the citation from 9 books, my lord. One book original I am having.
We have no expertise on that.
No expertise would be needed, my lord. Everything is a data.
Not
Here,
a
no
data.
inferential process or
Not a
expertise
data.
is required.
Everything cannot be a data.
That is written in the judgment. This is a data. Data is there in the books. Nobody can say the event of
What
it.
are the authenticity of those books?
My lord, authenticity is always guaranteed.
Yes,
my lord.
Are they included in the curriculum or
They are already included in the curriculum.
Suggested books.
Textbooks are there. My books are.
You suggest, I think you recognize certain books.
Well, I have no instructions on that.
You doesn't have any book. I have got
These are the books you have to consider.
Exactly. I can show all the books.
Come on Monday and just tell us.
Very much.
I got your point. Yes.
May I take one day.
What is the difficulty of the Monday?
I usually come from Sambalpur, that is how. One day.
So come on Sunday, enjoy here and then do it.
I have got another assignment there.
Tuesday. Doctor, item 47 that I do. So yes, we come to work.